in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.
Hey-o, folks, and welcome. Today is a huge day, folks. Today, potentially, can be the first day Judge Whitaker sits down and listens to the motions, and it can also potentially be the last. There is a possibility. I don't know which degree. There is a possibility if motions for mistrial is granted, it can be with prejudice. I personally, knowing a bit about courts and trials and stuff like that, and seeing a lot of trials the past 2 years, American trials. Getting mistrial with prejudice is probably one of the hardest things to get to. It is as unusual as a directed verdict. It just never happens. But one of the trials I covered ended with a directed verdict. So it does happen. It's just that it's so unusual. And but for personal reasons, for entertainment reasons, for grifting reasons, I hope Judge Whitaker waits with the motions of mistrial until last. Now, probably won't happen. My guess is Judge Whitaker wants to get the motions for mistrial out of the way first. Is it warranted? Oh yeah, it is. It is definitely warranted with a mistrial for prejudice. Hello, Dave. What time do the hearings start? Judge Whitaker has been adamant at an 8:45 start. Now, doesn't mean it will start. It just means everybody should be in place at that time. If, for instance, if one attorney for each of the defendants is there, the hearing will start. I assume the lead counsels for each defendant have been there for half an hour already. Nobody wants to be late today. Also, I've heard that Fani Willis will not attend today, which I find really, really weird. Since she wrote the defense motion or the motion to not disqualify the prosecutors. So if she doesn't handle it, who will? So I think that's really strange and actually really disrespectful if that happens. But that is just a rumor. That is just a rumor. Other than that, today will be a completely new kind of hearing. A hearing we have yet to have seen in this trial. A professional one. Nick Page asked, Nick, are you still coming to Atlanta in August? Yeah, everything is planned out already. Has been planned out for quite some time. The only thing that changes is if I'm going to visit another place on the way. For you who don't know, I'm traveling to Houston, traveling to the United States. My flight takes off the morning of August 7th and will land just about 2 p.m. in Houston. I will spend the weekend in Houston, and then I will go to New Orleans, then to Atlanta, probably via Montgomery. After Atlanta, Chattanooga, Knoxville, Indianapolis, and finally I will be in Michigan. And so I will start my journey on August 7th, and I will be in the United States until the 24th. So that is still on. Do you think Kamala is in town? I have no idea. Georgia is maybe a swing state. I have no idea. I don't follow politics. I mean, I do follow over here in Sweden, but since it's kind of important to follow the politics if you work with law. Lazy Ann says, I wonder who will speak for the prosecution. That is a very good question. Because Adrian Love can't, Simone Hilton can't, so who's left? I mean, you have the 2 or 3 other junior prosecutors there, but I've heard them try to conduct a direct examination of a witness, and in my opinion, might be nerves, might be anything, but there might be a reason they work in the prosecutor's office and is not in private practice. Red in 2016, blue in 2020. Okay. Sure. The only election that matters for me in Georgia is do not vote for Fani Willis. Do not. Jesus Christ. If you, for the love of everything holy, do not. If anybody is up against her, I vote for the other one. I don't even know who that other one is. I really don't care. Now, while we wait, I do have both the Law and C word and another source that I can stream from, so I will notice when it starts. But it can start from 8:45 to 9 or even a little bit after. I don't know. I hope it will start at 9 a.m. at the latest, at least according to how Judge Whitaker seemed to run her courtroom. But meanwhile, there have been a few new motions and replies to motion and replies to replies that I didn't cover yesterday. So while we wait, let's go through the first one. This is Bruce Harvey replying to the state's reply to his motion for mistrial and his objection to mid-trial substitution of the trial judge. So let's go through that one while we wait. Because if you were here yesterday listening to my rant about how poorly written the state's reply was, Bruce Harvey is a legend. And he takes Miss Love to school in this one. Comes now the defendant, Cormavius Nichols, by and through undersigned counsel, and files his reply to the state's response to Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge in the above captioned case. In support thereof, Mr. Nichols shows the court as follows. First of all, if you were here yesterday, this is how you write a headline or a header. Defendants were goaded into a mistrial. In Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge, Nichols adopted all motions and arguments for a mistrial as filed by co-defendants. As you might remember, Ms. Love argued that Mr. Nichols didn't provide law or anything. He clearly did. As adopted, Nichols' first argument for mistrial was that he was goaded into moving for a mistrial. Regarding this basis for mistrial, the state has offered only the most cursory response to Nichols and co-defendants. In the state's 4-sentence response, it appears that the state has merely given the state's opinion, which is the state does not agree with the defendant's characterization of events. And here, this is legal snark. This is shade. In response to the state's 4-sentence reply or response, Mr. Harvey submits a 3-sentence reply. 1. The state did not proffer the state's own characterization of the events. The state did not submit facts in support of its conclusion. The state did not present any legal argument upon which the court could or should reply. Oh, by the way, hello, folks. I see Kim here. I see Young here. I see Erin, Robert, Craig, Trey, Sion, Lacey Ann. Well, they were here for you. Too pretty for you. Paige, JMK, Siobhan, John Commune, Robert Harris Jr., Brittany, Harvey 2800, Samantha Yo, and a bunch of well, there's more than these people here, but these are the active one in chat. If you want me to say hello to you too, put something in the chat so I can see it. Let's continue. Although the state's reply gave little to which Nichols can respond, Nichols replies as follows. Nichols moves this court to deem the defendant's characterization of events as accurate, inasmuch as the state did not provide any facts or evidence to the contrary. Nichols moves this court to accept the arguments as made by the defendants because the state did not proffer any argument of its own in rebuttal. John Commune, thank you so much. That's so generous for your $20 super chat. To resupply the Wheel of Regrets. Thanks for covering. Wheel of Regrets will be on Friday, so we are a few days away from it. What I do is that I will find a piece of paper to write this down on. Yep. I should have brought a pen that works. Second pen. Let's try the third one. Ah! There. Dun, dun, dun. Okay, thank you so much. Court starting. Okay.
Any reply that got filed a response to order that I think makes sense. And the first motion that I am going to deal with is the motion filed by the state, essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions, I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrian Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred.
This
and
is
we would just
the
simply ask the
prosecution
court
whining
to
over
afford
defense attorneys
the relief
making
requested in
statements.
the state's motion.
All right, thank you. And anybody from the defense who needs to add anything to what's been filed in writing?
Good morning, Your Honor.
Good
Doug
morning.
Weinstein for Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV v. State 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. All right, with regard to this motion, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of up to them. And if there is a complaint filed, then they will have to deal with it. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion. Obviously, if facts change and the state or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to move forward without instituting any kind of a restrictive order for speaking with the press in the case. With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s, they're in effect in Rule 22 period, only permits recording when the judge is on the bench, not during any recesses and not during any bench conferences. So let's make sure that we abide by that from here on out. I was having to reference some prior live stream that was in some of the motions that were filed and some of the responses, and noticed that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right. So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order. Mr. Steele, is there anything you want to add to what's in the written filing?
Yes.
Go ahead.
Oh, that's a box with stuff. Brian Steele came prepared. Brian, this is, folks,
Good morning,
this
Your
is
Honor.
going
Good
to
morning.
be epic.
Good morning, everyone. Your Honor, may I just step back for 1 second?
Do you notice the calmness in this courtroom? This is such a huge difference
Good
from when
morning,
Judge
Madam Court
Glanville.
Reporter. I'm Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take offense to or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated July 8th, 2024. And what happened here is you have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable recused court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted. Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Miss Love, Miss Bumpkus, B-U-M-P-U-S.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in that.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness to change his statement. He made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case,
Okay.
I'll be right back.
This judge came prepared. I believe she is much more prepared for this than anticipated. And I find that really, really refreshing, because if it was something Judge Glanville wasn't, he was never prepared. Oh yeah, and Miss Love would have already stood up and interrupted. Yeah, this will be really, really interesting to see. I mean, look how the defendants are clothed. I mean, he's in a suit. I don't think I've seen him in a suit before.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay?
Yes, first motion. This is about Judge Krause's judgment, in which she made a comment about her believing that the ex parte meeting was proper.
Is this a case that's not cited in your?
Yes.
Okay.
With that, the judge indicates she knows the citations within the motions already. She's been busy.
May I approach?
Oh yeah.
Thank you.
Yeah, sorry. First motion was the state's motion to put a gag order on the defense attorneys were denied. Thank you, Dave. Yeah, she came to work today. This is so refreshing.
So, Your Honor, I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, ARCHER versus Maryland. It is 859A, as in at least a 2D 210 2004 case. And starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. That's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center, first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Prevas, Prevas, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process. And then skipping down to the next paragraph, similarly, it was.
Can I interrupt
Yeah,
you,
of
and
course.
let's not skip down, because I think that part we're skipping is maybe important too, because it talks about the specifics of what that judge did in this
Yes.
case. So what is that?
Okay, well, he did a lot of things. But what the court is referring to, under the circumstances of this case, the phone call to another judge in the presence of the witness, the threat of life imprisonment and a sanction for contempt, and the suggestion that the other judge will give Bailey the longest possible penalty for contempt detracted from the dignity and integrity of the judicial process rather than uphold it. Similarly, it was unnecessary and excessive to instruct Bailey on how he could testify in the Archer case. Mr. Archer was one on trial. Bailey was represented by counsel who could have advised him concerning the various testimonial options if that was deemed necessary under the circumstances. Even if Bailey was unrepresented, it was not in the province of the court to suggest to the witness how he could testify to avoid a contempt sanction or how to allay his fears of testifying. In either case, it was not the function of the trial judge to suggest to the witness that he could testify favorably to the defendant, Archer. Specifically, Judge Purvis advised Bailey that he could testify favorably to the defendant, and there is nothing that anybody can do to punish him for that. That admonition was incorrect because Bailey could be prosecuted for perjury. So it goes on. I mean, there's great language. And the reason I use it, I understand it's not binding precedent, is it's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, just to highlight, because I heard what you said, the witness said, can I have 2 weeks to go home on house arrest instead of in the county jail? His child was having a birthday. That was a big deal to him. And then I'll make a decision whether to testify or not. I want to think about it. That answer should be from the court, because the court can do anything in contempt. It can give a fine. It can give weekends. It can give house arrest. It could do nothing. It could say you satisfy your contempt. That answer to that question was done by Ms. Hilton in front of the judge. Ms. Hilton said, no, you cannot. You have to go to jail. I find that offensive. This is my words. And that's why I'm disagreeing with Judge Krause. Number two, Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is, nothing was done appropriate. I mean, so, and I don't want to get into, and the state actually filed a motion later saying the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said, I'm not accepting those factual findings, respectfully, because they're wrong, A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the questions, but Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Miss Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changes the complexity of the case. Because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded, except for 2. They track over 16 hours. The judge told him, and Miss Hilton told him, and Mr. Copeland said, you previously told me, meaning Miss Hilton, I could just say I don't remember. I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does as under Georgia law is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble. because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. So to me, as found by the Maryland court, this is intimidation. There was nothing appropriate. And the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree. And that's why I wrote that motion.
All right. Anybody else? And I know that there is another, or there are a couple more motions for mistrial based on the ex parte that talk about coercion and things like that. And I'd rather take those up in the context of those motions. So if that's what you want to argue, hold off. Otherwise, come on up.
Your Honor, good morning. Max Shard on behalf of Shannon Stillwell. Of course, under the Harvey rule, I have joined Mr. Steele in his motion. I would like to, I guess I disagree with Mr. Steele in one small aspect. He is seeking to challenge the findings of Judge Krause, the factual findings, is the way he's articulated it. And I too have concerns about the order in the respect that it suggests that the ex parte meeting was or could potentially be appropriate. I don't believe it was appropriate at all, and I know that we're going to get further into that. But Your Honor, I would my disagreement in where I want to veer off from what Mr. Steele was saying is that I don't believe that they're factual findings. They're not necessary for her ruling. I believe that they're mere dicta. I don't believe that they're binding on you at all. What Judge Krause's order said, I believe that you independently can take a look at the transcript and make your own determination about whether the ex parte meeting had an appearance of impropriety or whether it was in fact improper, which it certainly was. So I just object to the characterization of these as factual findings because I don't believe that they are. I believe that they're merely dicta, and I believe that you're able to make that assessment on your own. Should you view them as factual findings, I, of course, join Mr. Steele in his objection to those quote-unquote findings. That's it. Thank you.
All right. Anybody else from the defense? All right, I'll hear from the state.
Not color
And I know you
coordinated
haven't
today.
had a chance to see and absorb the Arnold rule, I think Arnold, the case that Mr. Steele just, Archer, shared with us before now, but.
Your Honor, I will use it as he has presented and just point out the most obvious omissions and distinctions that I see present with the Archer case. Mr. Steele stated to the court that Mr. Copeland had no privilege to invoke. He spoke about what did or did not happen during the meeting, during the hearing in chambers. I would ask that the court, as the court has already read the transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court as it relates to intimidation. Mr. Steele asserts that a statement made by Ms. Hilton essentially is part of what makes the hearing improper.
One of the statements.
The state has cited in its motion or its response to the court cases that support the state's position that this.
In my most humble opinion, this is a load of horse shit. The cases she cited, and I have looked into them, does not, because those cases they are referencing to are completely different situations, completely different.
This hearing was not improper. Essentially, in order for, as this is a motion to challenge factual findings, I'll speak to the factual findings that have been challenged. Again, Mr. Steele cites that Judge Krause's finding, the way he said it, if it had been made in open court, it would have been proper. The
All
court,
right, why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. And I believe, and Mr. Steele, you can correct me if I'm wrong, but I think that the factual finding, that's the second one you're challenging, if it even is a factual finding, is Judge Krause's statement. It is worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about?
Yes.
All right. Okay, Ms. Love.
thank you. And so given the fact that the court has at its disposal the transcript of the hearing, Your Honor, and given the case law that the state has cited to the court, specifically, Your Honor, Allen v. State, 336 Georgia App 80 at 81, citing King versus the state, a Georgia Supreme Court case whose site is 273 Georgia 258 at 264 through 265 as authority for its ruling that appellant had no standing to contest the grant of use immunity to a witness, and King versus the state itself ruled after an appellate.
This is a bit infuriating because Mr. Steele's motion does not regard the use immunity in itself. It is how Judge Glanville, Hilton, and Love commented to Copeland regarding his testimony and how long he would be in jail, the coercion stuff.
Complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity that would apply to that compelled testimony, that the hearing in question was not a part of the proceedings against appellant, and that while appellant, quote, might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order or that would suggest that appellant's rights were the subject matter under consideration and that appellant had no standing to address the matter of the hearing outside his presence. I bring up...
Yeah. Ms. Love calling it a brief is false on its face, complete false. It is an ex parte meeting and nothing else. And she goes into this, but this immunity is not improper, not giving him it or blah, blah, blah. This is not about the use immunity. It isn't. And even if it was, her case law doesn't really support her.
Those two cases, Your Honor, as well as Gilbert versus the state, and that site for Gilbert, Your Honor, is 306 Georgia App 776 at 777. Notwithstanding Gilbert's waiver, however, his argument is without merit because Gilbert has no standing to contest the grant of use immunity to Lang. The court again cited King and pointed out how the defendant there had argued that the trial court erred by conducting a hearing outside of his presence to determine whether a witness should be compelled to testify against him in exchange.
The difference is, in that case, that witness hadn't taken the stand yet. So you can't apply it this way.
For use and derivative use immunity. This court goes on to cite the portion of King that I just read to the court, and goes on to say, on the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which the defendant had no standing to address. In this particular instance, of course, there is the distinction that Mr. Copeland had invoked his right to not testify at a point where there was no, I'll agree with Mr. Steele, there wasn't a privilege to invoke. The point at which he said, I plead the fifth, is when he was asked, I believe, his age in years. The concerns that we had, we presented to the court, and mainly it was that Mr. Copeland, as is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hilton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered. The hearing in chambers, as is reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were. The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury. So yes.
I just interpose an objection. I don't have any problem with this love. I'll refer to the transcript, but if she's going to testify, I would ask that she testify as a witness. I don't believe it's proper that she proffers information. I believe if she wants to be a witness, which I do believe she is, she would have to be sworn to testify.
Remember, they want to call Miss Love as a witness, which means she cannot testify about what anybody said. She can argue why it's proper, what was happening was proper or not, but you cannot testify of the contents of that meeting since she is on the defense witness list currently.
All right, thank you. So I have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is whether I can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the authority, the court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's. Just as each court that...
That is sadly a really good argument. I hate to say it, but that is actually the only, this is what Ms. Love should have said and then sat down again. If the defense wants to change that factual finding, they might need to do it in the appeals. Yeah, Mamaro, she just switched gears and get to the point. I'm not that familiar with the Georgia rules, if this judge, the presiding judge here, can make a ruling. I do not know. Which will be really, really disappointing.
At each step in this process has its
But it is a clear appellate issue, that finding.
own set of duties. That one belongs to Judge Krause.
Okay.
So we would ask that the court deny the motion to challenge the factual findings of Judge Krause.
Anything else from the defense on this particular motion? Has there ever been an attorney invited to talk who didn't take the opportunity?
I took a pass a couple of times, Your Honor. Doug Weinstein for Mr. Kendrick. The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to and complaining about here. That is a hearing about the issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in Chambers on the 10th, far after that immunity decision was made. At least just speaking with respect to my client, Mr. Kendrick.
Okay, thank you. Anybody else? All right, with regard to just this particular motion, which is styled a motion to challenge essentially Judge Krause's factual findings in her recusal order. It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. To the extent that it is a motion to reconsider that court's order, that's a little bit closer to something that I might be able to do, but I can't really do that either. That, as Ms. Love correctly pointed out, was a motion to recuse Judge Glanville. It was before Judge Krause, not this judge, and she granted the relief that the defense sought. I understand that the defense does not like some of what might be factual findings in there. There are other motions before this court right now for mistrial based on that, and I think it is more appropriate that I consider them in the context of that than going back and essentially undoing potential factual findings made by Judge Krause. I think I agree with Mr. Sharp that this is probably dicta anyway, in that the essential holding that the court made was that the recusal was based on Judge Glanville's engaging essentially while making a ruling on the motion to recuse and making kind of more than just the minimal necessary findings in his ruling. But I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular motion, understanding that we still have other motions for mistrial.
Within the negative, this is positive, that this judge is already leaning towards this is not what got Judge Glanville recused. That was his conduct regarding the recusal motion. Her finding which means that once she denies that, because she cannot, as she said, make that ruling as a review court, but she can address it in another motion. This is completely fair, in my opinion. So that's the positive in it, that Judge Whitaker indicates that that passes in the order from Judge Krause. She reads this as a dicta, not as a factual finding. That is positive.
To take up where some of the arguments y'all made just now might be more appropriately considered. All right. So I think that actually the next motion I'm going to take up is the motion filed by Mr. Williams that has a very long style, but that essentially asks that any other ex partes be revealed, that a neutral judicial officer take a look at everything in the case that has been sealed and make sure that it is above board. And then for a mistrial based on the alleged judicial misconduct that occurred during the particular ex parte that was the
This is the
10th
third motion.
of June. And prosecutorial misconduct there and prior to that. So I got from the clerk's office every sealed filing from the state or any of the defendants in any of these 6 defendants' cases. I've looked at all of them. There's nothing improper about any of them. I refiled them. The order that it accompanies the resealing, I'm sorry, not refiled them, resealed them, actually delineates each of the things that I looked at or the dates of each of those sealed filings. I'll note that a lot of those ex partes were defense ex partes. There's nothing wrong necessarily with something being done ex parte. We're kind of talking about this June 10th ex parte as though, ooh, that is such a horrible thing. And it may be, but an ex parte in and of itself is not necessarily a bad thing. And both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper in my determination. All right. The next thing is the defense asking.
Okay, it seems like there are no other ex parte meetings in the fashion of this one with Woody, according to the judge. And those are sealed. These, yeah, as MG law says, the ex parte is presumed improper. So, yeah, that's a weird statement. But she said it as it is not necessarily bad if it's scheduling or anything of that sort. But apparently no other of the type as Woody was subject to, according to Judge Whitaker. And Woody was under oath. Big difference. All right. MG Law, hi. I will send MG Law a link. I know he's at work, I know, but it can be good to have a lawyer's opinion once in a while. And when I say that, a US-based lawyer. I do have a law degree, but my work is exclusively within labor law.
Whether there have been any other ex partes that we don't know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
Your Honor, not being certain whether the sealed filings include the transcript of the request from the state to have the hearing with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay.
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
All right. And was that done in writing or was that oral?
The request was done orally with the court reporter there.
Okay.
We requested that the court allow us to address the matter and that it be taken down for the record.
Okay. All right. Anything beyond that?
Yes, there was also the state's request for a material witness warrant for one of the.
I think those are all reflected, and you may want to go back and look, but I know that there were material witness warrant requests from several different parties in the case.
Okay. All right. So those are the ex parte matters that we addressed with the court.
Okay. Thank you. Mr. Weinstein, anything? Okay. Mr. Carlton, Mr. Matthews. Okay. Mr. Steele.
Oh?
To my best memory, which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement executed a search warrant for the computer of the Honorable Eric Johnson. He's a lawyer in the case who's severed out now.
Okay. All right.
And that was announced in open court. I asked the Honorable or I asked to recuse Judge Glanville whether we can have an ex parte. All the parties were here, and then everyone went. So when I say everyone, all the people here went into chambers behind, and there was conversation in front of a court reporter.
All right. And when you say all the people here, does that include the state?
No,
Okay.
the
So you
state
mean
was
all
here.
of the defense attorneys?
And the state was here when I announced that we'd
Okay.
like to meet ex parte. The judge, former judge reconvened, our former judge reconvened.
Okay.
We went into the chambers here. So I have no idea if that's something you looked at or not.
And I don't know whether that's anything I looked at because that would have concerned a severed defendant. I would imagine it's in that case and not any of these 6 defendants. And I only looked at what was in these 6 defendants' cases.
I can't
But-
answer.
Okay.
And then, and when I say who was here, yes, Honorable Mr.
Okay.
Matthews, Mr. Weinstein, Mr. Harvey, I assume Ms. Westmoreland, she's shaking her head. Mr. Williams, I know Mr. Adams was next to me, Mr. Sharp, I presume Mr. Bucks. He said yes. And the second one was also asked in open court for a meeting with the accused judge ex parte. And that was on the day before we're coming up to a man named Mr. White, like the color, was going to testify. And we had it at the bench where the court is. And that was Mr. Sharp, Mr. Matthews, Ms. D. Williams, myself, and Mr.
Yeah.
Adams. And if I miss, my memory's wrong, I
This
can
is the
correct me.
difference
That's who I
between
remember
the
being there.
defense and the prosecution.
And-
The defense announces it. So the prosecution is aware of it. The prosecution sneaks. And then, yeah.
And it was on the record.
Okay.
So I don't know if you saw anything about that.
All right.
And that was the total that I've had with.
All right. Thank you.
Thank you.
Mr.
More!
Harvey.
It's just to be on the safe side, it wasn't, we had a in-camera meeting with Judge Glanville, and I said meeting, it's not ex parte, it was meeting this West Forward, and I believe a Hilton. But the concern is scheduling conflict in federal court.
Okay.
That I had, and we resolved that, I just want to make sure.
All right. I appreciate it. Thank you. Mr. Sharp.
Your Honor, to the best of my recollection, I recall being with Mr. Steele in the announced ex parte regarding that gentleman, Mr. White. I also believe there was an ex parte regarding another permission to interview a separate witness who was unrepresented at the time. I believe that probably is reflected in the sealed records. I can't recall if Mr. Steele was with me or not, but that also occurred, and that would have been before the jury was sworn. That was late 2022.
Okay. Thank you.
Mr. Steele is indicating that he was present.
All right. Okay, so that takes care of that part of that motion, unless anybody wants to inquire further as to any of those. Okay.
Oh, no. What's confusing to me, Your Honor, is in the transcript of the June 10th ex parte meeting that we focused on, there is, within the transcript, there's a clear indication that Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of, that they seek answers from Mr. Copeland about and wish to pass these questions on to him. There is nothing in the transcript that indicates a discussion between, I believe it was Ms. Hilton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically. So that's my concern.
All right, so I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumed surely you must have given them a list of questions. Now, I have no idea whether if it was just like, surely you have a list of questions, or if there had been a prior conversation, and I will ask Ms. Love that.
Your Honor, I believe that since Ms. Hilton was the one present.
Or Ms.
at it,
Hilton.
But I can say that I did hear Judge Glanville, I believe, in open court say something similar to that, but I will allow Ms. Hilton to
Okay.
address this.
All right. Ms. Hilton was Was there some basis from something that had already occurred for Judge Glanville to have asked that?
No, Your Honor. We were very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting.
All right. And was everything that occurred in that meeting other than
The wording of that was strange. She's not denying that there were questions. She's saying she didn't discuss it with the judge. The wording there is very specific. I need to hear that again. Sorry. Let's hear that again.
Very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville.
We never talked about any questions with the judge. That is very specific wording. That leads me to believe there were questions, but we might find out if this trial continues when Mr. Copeland gets cross-examined. Yeah, as MJ Law says, she didn't discuss them with the judge beforehand, but the questions were asked about substantive issues.
Saying that during the meeting.
all right. And was everything that occurred in that meeting other than the times when Judge Glanville stepped out so that Mr. Copeland could talk to his own attorney and I believe talk to y'all? Was everything else recorded?
Yes, Your Honor.
Okay, from the outset of that meeting.
From the outset of the time that I entered the room, everything is recorded.
Right, because you weren't there at the beginning of it.
Correct.
But you did not have a conversation with Judge Glanville prior to when you came into chambers and it was being taken down?
Outside of
About
the normal,
how are you doing?
pleasantries
How
and
was
conversation.
lunch? Yes.
Correct.
Okay. Ms. Love, you were in there at the outset. Was it recorded, taken down from the outset?
Yes,
Okay.
I said it was. She was there from the beginning. And as I stated earlier, the only other instance that we spoke on that was also taken down.
Okay. All right. And that was earlier that same morning?
I think it was the Friday.
The Friday before? Okay. All right.
So they spoke on the
All right,
Friday
so-
with the judge as well?
Based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville regarding Mr. Copeland and what they discussed in that June 10th ex parte.
Yeah, based
All right, another
on-
part of this motion,
based on the information we got. Yeah, but I do believe the prosecution is lying simply because they speak.
is a list of purported slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional. All right?
I will continue to do that as I have.
All right.
For all parties to make certain that.
I would. Did you hear that? You lying sackish. Ms. Love had the audacity to say she will continue to do that. She hasn't done it since the beginning of this trial. Not once. Not once. And this was Judge Whitaker telling Ms. Love really nicely, don't do it. And Ms. Love says, I've never done it.
Okay. All right. With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, I'll consider something that y'all want to present to me. But I know in particular, Mr. Steele, you took issue with apparently at some point, Judge Glanville used some adjectives about you, specifically unprofessional and unprepared, that are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared. And so that ought to take care of that. And this court is going to instruct the.
That is, I don't like that. The judge, never in front of the jury. If the judge can't hold stuff back, then he should get the jury out and then yell. Coming from the judge, because the jury looks at the judge as this impartial god of the court. So if the judge says you are unprofessional, they will listen. This is not a matter of letting the jury make the determination, in my opinion.
Jury, just like is done in every case, that nothing that the judge says, no matter whether it's this judge or the prior judge, is evidence. It's not supposed to indicate any kind of a bias one way or another. And so I'll give those.
That is not evidence. That is characterization, which you can't do in a court of law.
Curative or those instructions anyway. And if you want something additionally curative wise, I'm willing to entertain that as well. Okay.
In my mind.
All right. So given that Judge Glanville is now recused from this case anyway, and I have instructed Ms. Love to conduct herself with professionalism, I am going to deny the motion for mistrial as it is sought and on the bases on which it is sought in this motion.
Your Honor,
Yes.
I just asked for clarification, whether the court is finding that there were any unprofessional or.
I am not making any such finding.
Thank you.
Yes.
I think we just, maybe I was lost for a second. I think we switched to a place where I didn't believe we were at, or I didn't understand the discussing regarding a mistrial. I didn't really understand us to be at that point in the motions yet. And I just wanted to be clear for the record, to the extent that a mistrial was denied. Mr. Stillwell, it has been we never requested a mistrial.
Okay.
And to the extent that a mistrial has been denied, I just want to be clear that Mr. Stillwell has not requested a mistrial. And when we were going to move on to Mr. Harvey's specific request for a mistrial.
Yeah, I hadn't gotten to that one yet. Okay. All right. I appreciate
I just want
that.
to make that clear for the record.
Okay. Thank you.
Okay, that takes care of that. Judge Glanville's conduct towards Mr. Steele and Mr. Shard in open court in front of the jury is not enough for mistrial. All right.
So now we get to the motion to disqualify attorneys Love and Hilton, the two of the main ADA prosecutors in this case. And the basis for that, this is also filed by Mr. Williams, is that they assert a need to cross-examine Mr. Copeland, attorneys Love and Hilton, and Judge Glanville with regard to the ex parte. Anything that, Mr. Steele, you want to argue that's not in your motion with regard to this? And I do have a question for you about one thing that you said.
Okay. Now this is a big one. This is one of the big ones.
Yes, Your Honor.
You want me to ask my question first?
Whatever you tell me.
So in your paragraph 3, you assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
Okay. So going back to what you've read and digested June 10th, 2024 ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. What Prosecutor Hilton and what Judge Glanville were telling Mr. Copeland was, you can say lies, as long as they're not big lies, and you will not be prosecuted. He could be prosecuted for perjury and false statements.
Okay, and when you say that, do you mean when it was mentioned that if you say, I don't remember,
No?
you
I said
can't be
it-
prosecuted?
No, I have to get the transcript in front of me, but it was, as long as Ms. Love told you, which is not in the transcript, but the Judge Glanville said, as Ms. Love previously told you, remember is the word used, unless it's a big whopper of a lie, you will not be prosecuted.
Do you have access to the transcript right
Yes.
now?
May I step back?
Yes, and of course, I thought I brought it up here with me too, but I don't seem to have it in front of me either.
Hold on about the judgment about Judge Whitaker just yet. And yeah, I do remember that line that that both Judge Glanville and Miss Hilton more or less told Kenneth Copeland, aka Woody, he would not be prosecuted for any lies.
You may. And I'll give that back to you. I've got a copy somewhere, just given that we're using a borrowed.
And by the way,
Bench
there's a
and
new court reporter.
I don't have everything in my
Old court
fingertips.
reporter
All right.
retired Friday. Yeah, as MJ says, the use immunity only protects Woody from statements being used against him. It doesn't keep the state from going after him using other evidence or statements by others. I forgot to send Angela a link. Sorry, folks.
But he
Okay.
handed me from the transcript of the ex parte hearing, June 10th, 2024. He directed me to page 40. It's Judge Glanville speaking, line 20. What will get you in trouble is you not, is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you lie, if you overtly lie about something, like if you tell a bold-faced, not big whopper, bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement. And then Mr. Copeland said, that's what they're going to do. In this conversation by Ms. Bumpkus, that is what I was saying. You will be right back here. Then Ms. Hilton said on page 41, line 5, but if you say something that you know that you did not do, like you admit to something you know you did not do, whether you, and then Mr. Copeland said, like murder, don't have like no statute of limitations, right? Ms. Hilton said on line 10, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland saying, but y'all don't like ... His lawyer said, you could charge him with false statements and he will be back in jail. That's what I'm trying to say. And then Ms. Hilton on line 17 said, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it. And the judge is there. So I hope that's answered your question. There's another space that I can find. I just need a second. But it's the judge saying you won't get in trouble. He says that throughout. You can say you don't recall. You won't get in trouble. There's also a place in here where the judge tells Mr. Copeland and Ms. Hilton that the statute of limitations, this is Ms. Hilton, the statute of limitations has run. In federal court, she says, I looked it up. In federal court, it's a 5-year statute of limitations. In Georgia, it's a 4-year statute of limitations. If I could get that site for you, I'll tell you exactly where it is. What page? I'm being told 24, Your Honor, but let me check. Mr. Adams said 24 going to 25. Your Honor.
Yeah, everything about that ex parte meeting and how they coerced Mr. Copeland into testifying.
On
It is
page
so bad.
24, line 12, what I see.
Unprecedented in Georgia. That is why they can't find the
Ms. Hilton
exact
says,
case
and
law.
what we'll say, and Mr. Copeland and I, we've talked about this. I'm not sure what your concerns are. What concerns that you expressed to Mr. Melnick last week. But if you are, if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, Ms. Bumpkus interrupts. Well, that's not, Ms. Hilton interrupts. It is true. Ms. Bumpkus, said, no, I said that's not his concern. Ms. Hilton said, if it's his concern for his safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, that we can try to resolve the concern. This is what I'm saying, Mr. Copeland, and I have had conversations before going to page 25, Your Honor, and here it is. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So there is nothing, like I researched it this weekend again, both those statute of limitations for what you and I talked about, which is a 2015 or before done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that's a concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything 2015, 5 years would have.
This is a commentary channel, remember that? This is where Judge Glanville, Ms. Hilton, and Ms. Love were lying to Copeland. They can guarantee he won't be prosecuted for anything, regardless of what he says on the stand. They can only grant immunity for what they discussed that they claim the statute of limitations has run out. Here's the thing, folks. Say Mr. Copeland finds himself in a RICO trial where murder is involved. Murder, then everything gets back in. So they can't guarantee he will not be prosecuted. They can only guarantee they can't use his statements in a prosecution.
In 2020, anything state where it's 4 years, it would have been 2019 finished. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
It sounds to me like they're talking about some kind of particular crime he might or might not have committed that he might be testifying about, and whether that obviously wouldn't be murder because, as he recognized, murder has no statute of limitations. But that sounded like it was a really particular crime.
You can't tell a person, I wouldn't tell a person, how about that? You can't be prosecuted because statute of limitations ran when you know he could be prosecuted in our indictment. The state is saying,
agreed.
Yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly, you can't be prosecuted for anything.
I don't know.
Okay.
I don't read it like that.
All
so
Baker-aid.
On the next page 26.
Baker-aid, okay. Hey, Baker-aid. This is the first hearing with the new judge in the Young Thug trial. And it is a completely new atmosphere. It's conducted much more professional. I have a bad feeling. About this judge. Although she is on the point, very clear, everything. I mean, you can't get away from this, Judge. Prosecutor Hilton and Judge Glanville lied to the witness in order to get him to testify. It doesn't matter if it is specific cases. They still lied to him to get him to testify.
It's again, Ms. Hilton, line 2, you will not, this order, I don't know.
Can I interrupt you for just a second,
Sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you to address that.
We need you to testify. Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of? That's not true.
Okay,
That's wrong.
Yeah. That is on. That's on page 36 of the transcript.
Yeah. This
Lines 3 through. I mean, the discussion's kind of lines 3 through.
He is prepared.
9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers, forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. we're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015, that you found yourself in an office with a judge? Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly, you spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript, and I know everybody has said, oh, there was Brady in there. Y'all got it all now. So it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify.
But they still lied to Copeland in order to get him to testify.
Maybe all of the things that happened in there, that may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about all of, you may have to stay in jail till all of the co-defendants trials on page 36. Anything else?
We need you to testify. Nobody needs him to testify. I mean, he could do whatever, it's America. He could do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty of perjury, but that's the judge. And they also tell him how to testify. Judge Glanville tells the lawyer first. If you remember, I could get you the transcript. You remember, you're shaking. Judge Glanville tells the lawyer.
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
Okay. It's at the beginning when Ms. Love was there. Hold on one second.
As Heather Moshe says, when Judge Glanville says, we need you to testify.
I'm being told page 30, line 5.
And in my personal, not so objective opinion, that what happened in that ex parte meeting should render a mistrial, possibly with prejudice, because the judge at the time with the prosecutors conspired to get a witness to testify in an order they wanted. That is coercion.
Okay, page 30, line 5 is Mr. Copeland talking.
Give me a second. Okay, so I start with page 8.
Page 8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions at.
No, where he gave legally incorrect information to Mr. Copeland.
Okay.
Which is what you put in your motion.
Well, okay, and page 8, though, if you take into consideration, starting on line 9, the former recused Judge Glanville is telling the lawyer for.
Sorry again. Thank you so much, Iron Rabbit, for your donation via PayPal. $20 is very, very generous. Very, very generous. And for you guys who do not know, I will be going to the United States. I will be there between August 7th and August 24th. I will be traveling from Houston up to Michigan via New Orleans, Atlanta, Knoxville, Indianapolis, and then up to Michigan, and with some stops along the way.
Mr. Copeland. Now, to be fair, I think Ms. Bumpus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bumpus says yes. Or
was that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors. The judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge starts telling him that the client, he's telling Mr. Copeland that the client should guilty.
Mr. Copeland's not here at this point in time. This is his attorney, Ms. Bumpus.
All right, let me get that for you. It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find it. Okay, on page 26, Your Honor. Line 16,
Uh-huh.
Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe, Mr. Copeland, are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted,
But he can be prosecuted for this case.
which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page,
Well, if you are, I mean, if the topic of the meeting is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting.
He can still be prosecuted. Use immunity, unless I'm reading the Georgia use immunity completely bonkers. He can still be prosecuted. They can just not use his testimony in that prosecution. And judges shouldn't say, oh, I had so high hopes for this judge. For anybody who was worried that I might not curse at this judge, I think you worried in vain.
And the nuances of that. I mean, that's a nuanced issue, even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
okay. On page 30, it's not the judge now, it's
This
Mr.
judge
Copeland
doesn't
speaking.
understand immunity either.
Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you called, went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember. Excuse me, I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talk about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms.
Okay.
Love. That was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And
So-
I want to ask questions.
Okay, so Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been taken care of.
But, well, you just said, but his conduct during his stay on the bench in this trial, does that warrant mistrial? Just because he's not there yet does not mean his conduct didn't affect the defense negatively.
Standard law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. Ms. Hilton said, no, there's another 12. The court said, there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't
Okay.
just hold a human being.
All right, so you can certainly ask Mr. Copeland about that.
Okay.
I don't know that the prosecution's motivations are relevant to the issues that the jury is supposed to decide. And with regard to Judge Glanville, again, he is not involved in this case anymore. So I'm definitely not going to permit you to cross-examine Judge Glanville in front of the jury because frankly, it's irrelevant. And
What?
he's been recused. So to the extent
That's not even a part of this motion. She already said she will not allow the defense to call Judge Glanville. It's absolutely relevant for freak's sake.
Not that, do you have anything else with regard to why it is you ought to be able to have Ms. Love and Ms. Hilton removed from the case?
Yes.
Okay.
So, and just go back to your answer, last question, page 44, line 22, it's Judge Glanville speaking.
Mm-hmm.
And he said, okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that's what the order said. That's just not true.
I'm sorry, where are you?
Page
I may be on
44.
44.
Line 22, Judge Glanville.
Oh, okay, I'm with you,
Speaking.
yeah.
He said, okay, this is Judge Glanville. So you testify about some aggravated assault or murder.
Okay, so I'm
They can't
actually not
prosecute
with you.
you.
Page 44, line 2?
22.
22, okay. All right,
Judge
gotcha.
Glanville speaking. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute and they can't use his word.
Okay, all right, I will take all of that into consideration. I don't think that I'm going to make a ruling on this particular motion today. I want to take a full look at all of it in context, because I do think we have to consider it in context. I will note that one down as well.
So let me then answer your question directly. So what's going to happen in my mind's eye is I'm asking all these questions to Mr. Copeland. He's answering however he answers. I am pointing fingers at the two prosecutors. That mandates that the jurors have to rate their conduct that happened outside the jurors' purview. I am saying that he being Mr. Copeland, was given erroneous legal information. He was encouraged by the holding of hands of Judge Glanville, Ms. Love, and Ms. Hilton, that they all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify, Judge Glanville said. Mr. Copeland will say, I don't know what he was going to say. But yes, I felt that. I felt that they were not going to let me out of jail. I can't then nobody should have. Then lawyers stand up when the jurors now need to rank what they are doing in the case. Their conduct is at issue. I'm not making them witnesses. I'd rather they stay on, to be quite frank with you. They made themselves witnesses. And the reason is because they injected themselves in such my opinion, inappropriate communication with a court and a sworn witness who did not ask any questions. The gentleman was represented by known counsel. He said, and it's in here, I can give you the page, but there's no reason. Take me back to the jail. Judge Glanville said, do you want to talk with your lawyer, me, or the state? Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this to me is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Ms. Love. Ms. Love, I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Ms. Love tell you? Or tell your lawyer, if your lawyer told you. And I understand I have to stay away from attorney-client privilege, but did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember, Ms. Love told you. We just read that. I want to talk about that. And then at some point, I want to ask Ms. Love, why would you tell a human being that he's going to just rot, in my words, rot in jail until 26 people are gone, which is not the law? And Ms. Hilton, why would you tell him that if he lies and you know he lies, you're not going to charge him? Why?
Okay,
And those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that. But if you look back at June 10th, 2024, about 11 o'clock in the morning, not the ex parte hearing, recused Judge Glanville comes on the bench. Please look at the transcript because I'm not verbatim. I understand that Mr. Copeland's going to testify. Mr. Copeland's put on saying, are you going to testify? He said yes. And we rolled into questioning. I don't know how it got away from the prosecution, Ms. Love, Ms. Hilton, Judge Glanville. By the way, he told us things that are specific on the case. He said in here, I can give you the number, I committed all these crimes All these crimes include murder. He's asked about statute of limitations for murder. We don't get any of that. So for all those reasons, I'm going to cross-examine Mr. Copeland. I'm going to bring all that out. And the people who are at the heart of that conversation are witnesses as well. They should not have done it. Then they tried to hide it, which I'm bringing out as well. And then just, I don't know how, but by circumstance, fortunately, whatever the right word is, we did get the transcript. If you read the transcript, I asked Judge Glanville for the transcript. He told me it was privileged.
All right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury.
Well, we'll get there when we get there.
But this is not, I cannot call anyone else. It can only go in the mind of Miss Love. Why did she call the meeting? I don't know. Anyone else could answer. No one asked for that meeting. This is my understanding. And Miss Love stands up here and said, we needed to answer questions because Mr. Copeland asked questions. I don't see that. He's represented by a lawyer. I don't see that.
Okay, well, thank you. I appreciate it.
Anyway, that's the basis of calling. I heard what you said about Judge Glanville. That's the basis why I want to call Judge Glanville and ask why did he join the prosecution team? And I believe that then dovetails into Judge Glanville saying wrongly that I was not prepared, wrongly that I was unprofessional. And then he later acknowledges that, but he says, I'm not going to instruct the jury. So the jury's never heard that. And I heard what you said, that you'll instruct the jury, but I'm going to argue that instruction, that the judge has no role in the case except, it's not verbatim, but except to make sure that every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is permitted argument or not if we get to that.
Okay, but that's my strong belief
All right.
that the jurors get to know that who the judge was for
All right.
18 months.
Mr. Sharp, you look like you want to say something.
Thank you.
Yeah, I'm really disappointed.
And I'm trying not to focus on things that we're likely to
Okay,
discuss.
and yeah, remember that this is the motion to disqualify Ms. Love and Ms. Hilton.
Right. I would just like to stress one point that, Your Honor, I know that you have joined us and weren't there on June 10th. I think it's important to remember when we're talking about the potential to call the prosecutors as witnesses. My understanding, I know I didn't call an ex parte meeting. My understanding is that Kenneth Copeland did not request an ex parte meeting. My understanding is Caleb Bumpus nor John Melnick, who served as counsel for Kenneth Copeland, did not call for an ex parte meeting. They did not express any concerns. The state called for an ex parte meeting. And in the beginning of that ex parte meeting, with Judge Glanville explaining the need for the ex parte meeting, the state made statements to Judge Glanville that accused Attorney Melnick of violating his oath and of not fulfilling his professional responsibilities and representing Mr. Copeland. They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge. And mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love stated to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Shard an email, and he may have inadvertently included us, possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them, and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient. There's absolutely no, the reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties in dealing with an attorney and not with a represented individual. And somehow the state in this ex parte meeting where we were not allowed to respond or even to hear the accusations, they suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive. And again, we weren't there. That's the problem with these ex parte
All right,
meetings.
well, I'm going to get a transcript. I have just typed a note to Judge Glanville's court reporter requesting the transcript of the request for the ex parte itself. So I'll find out what it said and I'll share it with everybody.
Okay, well, that's in the beginning of the transcript that you have. It's in the first 6 pages, I believe. In fact, page 3 to 4.
Okay.
page 3 to 4, they talk about this email, and we have the email.
Oh, no. I know the email.
Okay.
I'm talking about, I'll get the transcript of the Friday request as well. But yeah, I mean, I've seen the
And-
email. It's made an exhibit, I think, to the ex parte transcript.
And just so we're clear, and the reason I say that's important, because again, why are they doing this? What was the purpose of the meeting? Because that couldn't have been the purpose, because their stated purpose was completely inaccurate. And I would invite the court, I believe it's in the record, but we can certainly provide a copy of said emails.
It's an exhibit.
Okay, because that's not an accurate rendition. And I'd be happy to answer questions about what happened, but that was not accurate. And these are issues that now the state has injected themselves. As Mr. Steele said, we didn't do this. We didn't do any of this. In fact, we were excluded. We knew nothing about it. And it's improper, and the state initiated all of this. And it's not just what happened in the ex parte meeting, but why did it happen? And ultimately, there's only 2 people, I suspect 1, but we'll say 2, that really know why this meeting was called. Because it wasn't called by, my understanding, Judge Glanville either. It wasn't called by his staff. It was either called by Ms. Love or Ms. Hilton. And we have the right to cross-examine them or examine them about that.
All right, thank you. Response from the state.
Yes, Your Honor. Again, Adrienne Love responding for the state.
And I want to hear what you have to say. I've got your response. That's your written response. It's pretty thorough. So let's highlight what needs to get highlighted without
Her
rehashing
response was
everything.
That was my intent.
Not to suggest that you would, but
Your Honor, I'd like to point to the court, McGlynn, MCGLYNN versus the state, 342 Georgia App, 170 at 173 through 174. In McGlynn, the court notes while Webb dealt specifically with statements made by a trial judge, this court has previously noted that either judicial or prosecutorial intimidation that dissuades a potential defense witness from testifying, or the defense can, under certain circumstances, violate the defendant's right to present a defense. However, such analysis must be undertaken on a case-by-case basis. Here, we note, as did the trial court, that nothing in the record suggests that the statements made by the ADA to the witness were legally inaccurate or misleading. In fact, the ADA's comments seem to have been confirmed by the witness's own attorney, who, unlike the ADA, is charged with acting on the witness's behalf and protecting his rights and interests. As we observed in Terry, the potential for unconstitutional coercion by a government actor diminishes when a defendant's witness has consulted with an independent attorney. That these statements by the ADA were later perceived by the witness as threatening is wholly irrelevant to our consideration of this matter. The court has held that the state is duty bound to inform the witness of the possible consequences of admitting under oath facts that could place the witness in legal jeopardy, including notifying the witness that the criminal law would be enforced to the full extent against those who violate it. And that's the court citing Murray versus the state, 157 Georgia App, 596 at 598. As of course, the court has noted, we have included in our response the applicable case law that we believe is most relevant to the court's consideration of the motion to disqualify. In this particular instance, Your Honor, I would assert that.
And why is Ms. Love arguing this when it was Fannie Willis who wrote it? If this should be the same as a judge speaking in self-interest, they can't. It should be Fannie Willis there doing this, not Ms. Love.
The why of any particular proceeding is not a material issue, is not something that is relevant to the juror's determination of the guilt or innocence of either defendant in this case. It's not in any way. It's, if anything, it would be the effect of anything said on the witness themselves, and the witness himself could testify about that. In addition to the fact, as we stated in our brief, there were multiple people there as reflected in the transcript, and there's no reason to, there's no need to resort to an extreme remedy as disqualifying the prosecutors in this case, any more than we would have the right to cross-examine Mr. Steele or Mr. Sharp based on what they may have said to Adrienne Bean or anyone else in this case. So we would ask that the court simply deny the motion for such an extreme step as disqualifying Ms. Hilton and me. And we would base our argument on what we presented in our brief.
all right, thank you. You know, something that's tied up with this issue is the fact that, there's been a motion filed with regard to it, and we haven't gotten to it yet, but I think the defense is correct, and I don't think the state opposed the fact that everything after at least the 14th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, or virtually all of it. And am I correct that the state pretty much concedes, agrees that that's true?
After the point where the motion to recuse was filed by defendant Kendrick.
Okay.
We don't disagree.
All right. So, and that was the 12th?
I believe.
Yeah. So, we may be having really kind of an academic discussion about all of this anyway, because if what the court is going to have to do, and I invite y'all's input on exactly how to instruct the jury about this.
How to?
If we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly.
How to instruct the jury? How about if you even can instruct the jury? What the seriously? Oh, this is going way down. Yeah, it seems like this judge already made her mind up that this trial will go to the end no matter what. Mr. Copeland's testimony alone is longer than most murder trials. And they just say, whatever, we'll just instruct them to ignore it. Bull.
Can. We're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but we have to sort of think about that as well. All right. So I am going to take this particular motion under advisement, and I'll get you a ruling quickly, but probably tomorrow. Sure.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify the 10th, 11th,
Right.
and then the 12th is what
Right.
you referred to. And I understand we'll take up that motion tomorrow, but there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
Okay. Well,
want you to-
what I mean that we'll get to tomorrow is how to, and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before. The testimony that occurred before can stay.
Okay. I misunderstood what
The
you-
testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then that will be great, because it'll save
this
us
is already
time
recorded.
and we'll have better contours about what we're dealing with. So I want y'all to get together about that, and we'll think about that probably tomorrow, maybe the next day. I don't know, but not today. But y'all after court today can think about that together with each other. Okay.
The reason I stood up, though,
Yes.
I just wanted to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Sonoma court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick et al.,
Right.
and you're intimidated, and that's why you're not testifying.
Mhm.
I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state order to be witnesses? I need that in the case. because-
Okay, let me ask you this though. Why can't you use the transcript to get that point across? It's right there in the transcript. What it is that you assert to be intimidation is in black and white in the transcript.
I'm intending to cross-examine or examine Lawyer Hilton and Lawyer Love.
I know you're
On how
intending
they-
to, but what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how'd you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state. My point is, I can't ask Mr. Copeland
But the
happened to these other
issue,
witnesses.
as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland
Right.
into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need.
The transcript is not sufficient because the transcript is just what happened. The questioning needs to be why it happened. And that they can only, the motivation for this to happen can only be testified to by Ms. Love, Ms. Hilton, and Judge Glanville. And just putting it in front of the jury, I think this is not a matter of fact. This is a matter of law, and that is up to the judge. But this judge, as Judge Glanville seems to be adamant in, put it in front of the jury and we will see what they say, which is infuriatingly bad.
To be kicked out of this case. I think the transcript is what you need and what you have, but we'll take that up later and I will think about that.
Thank you.
Okay.
Excuse me, Your Honor.
Yes, sir.
May I just briefly address something you said earlier? Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out.
Right.
I do not, just for purposes of the record, I do not concede that this trial can continue.
I
that we
understand.
Okay, I just want to make sure.
A couple of motions from.
Just want to make sure that's there because you're asking us to meet tonight to go over what could possibly remain.
Well,
and I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No, absolutely. I understand that. We'll follow whatever order that you give, Your Honor.
All right, thank you. Okay, so the next motion is Mr. Nichols' motion for mistrial and objection to mid-trial substitution of trial judge. And it is quite lengthy and detailed with many subparts. Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to
Well, there
talk
is.
about?
There is.
You want to come up here or it's fine if you stay there and hold the mic. That's fine.
Well, what I want to say is I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks.
Yes. So
Okay.
I think that needs to be addressed first. And then our motion was in the alternative. If you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
Okay.
So I think that would be the
Okay.
appropriate.
Fine
We're
with
gonna-
me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, one, I joined theirs, they didn't join
Okay.
mine. So it's a
right.
second step.
That's fine. All right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first. And his motion asserts his motion joined by everybody else except for Mr. Stillwell. Is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kennedy's motion,
for mistrial filed July 23rd.
so let me, may I make my stance clear?
Yes.
I agree with MG Law. It's simply not possible for the case to
Our
properly
stance, Mr.
proceed.
Stillwell's stance is that this trial is completely broken. It's broken. There's error in this trial that would never survive appellate review. Illegal ex parte hearings have occurred. Our client's rights have been repeatedly violated. The defense has been mistreated in front of the jury by a partial judge. It's broken. we are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but
what he's saying here is what is reflected in a few of the motions. They are not interested in only a mistrial. They are only interested in a mistrial with prejudice. And if the judge can't grant that, they don't want a mistrial at all. Then they just want to move forward.
I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Thank you. Okay. And, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so Mr. Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that this mistrial goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that any mistrial would be with prejudice.
Yeah, the defense argues that this can only be a mistrial with prejudice because only a mistrial would severely hinder the defendant's rights, because then they will be sent back to jail, possibly without bond again, and stay there until the next trial starts, which is completely unfair. Because imagine the jury acquits them for the endings and most of the serious crimes, but find them guilty of some misdemeanors, which is also within the charges. Then they not only have they done the time, they have long exceeded the possible time to be in prison for.
Prejudice without the ability to try, amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my argument. Motion put forward. Those are exactly
In the ex parte concept of, which we've kind of brushed over somewhat, that Judge Glanville's comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues.
They also filed it. If not, any mistrial would be with prejudice without the ability to try the case over again. But the determination has to be made whether the state had the ex parte on purpose with the purpose of goading, to use Mr. Kendrick's attorney's word, the defense into making a motion.
Judge. It's not about the purpose. It is about the unavoidable result of it. Oh, no.
For mistrial, because the state thinks they're losing the case and wants to be able to do whatever with. I got the concept right?
Yes, Your Honor.
Okay. All right. So this is also a lengthy and well-briefed, well-written motion. I will hear what you want to add that's not already in your written motion, if anything.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
as a lawyer, I feel compelled to speak to it, but I will sit down,
Okay.
given that I have no additional information. I would like to respond if the state does have something to add. I did not see a filed response from the state to our motion. I was served a response, so I'm not quite sure. I'm not quite sure what that's about, Your Honor.
Now, sometimes they get filed, but they don't show up in Odyssey for a couple of days. Because y'all have been good about emailing the court when you file. I haven't actually checked Odyssey to see whether it's in there or not, but I would imagine that if the state served everybody with a response, they also filed it. If not, they need to. Okay, so that is a part of this motion. And another part of the motion is, well, I think you say as well that we'll need to redo the from 612 on.
I thought they were covering the Nichols
That's a
motion.
part of this motion.
That is a part of this motion, Your Honor, yes, that there is a requirement that everything after 612 is void.
Okay.
And in that motion, we argue what I stated earlier, that I don't believe it's possible
That it's
to erase
possible.
that information from the jury.
Okay.
Also, I'm happy to take any questions you may have.
Okay, I appreciate it. All right, so, yeah, so there are a lot of different grounds in here. There's the state sought it because they wanted the defense to ask for a mistrial so they could get a mistrial and try the case over again. That substantively speaking, the ex parte was a critical stage at which the defendants were excluded. And then the concept of, which we've kind of brushed over
they went
somewhat,
Thank
that
you. They went back
Judge
to
Glanville's
Kendrick's motion.
comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues, three main arguments that I put forward in that motion. The only thing that I can think of that maybe I did not sufficiently highlight is just the tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As Mr. Shart has said, we are winning this case. The state's witnesses have not testified the way that I imagine they expected them to testify. And I do not believe that they should be allowed a do-over in this case, Your Honor.
All right.
But I'm not going to repeat what's already
Okay.
in front of you.
Okay,
Thank you. Again, if you have questions, I'm happy to
All right.
answer any.
And then also sort of in this motion and asserted in a lot of the defense motions are what we've again touched on, that Brady material arose from this ex parte and y'all have it now, so it's not a Brady violation anymore.
And that-
No, there was.
And that's not a real requirement in order to grant our motion, Your Honor.
All right, I just wanted to make sure I covered that as well.
Well, the attempt from the judge and the prosecution to hide it, even though they should have had this information before the trial started. And they refused to give it to them after 5 days of testimony. It's still a Brady violation. Just because they have it now doesn't make it not a Brady violation anymore. It's still a Brady violation, subject for punishment. Oh.
Okay. Does the state want to be heard with regard to anything not already in their response?
Yes, Your Honor.
Okay.
Just based on Defendant Kendrick's representations to the court that and others that they're winning, and therefore we go to them. If they're winning, then let's just keep it rolling because the state vehemently objects to a mistrial.
Okay.
And I am unclear how we are arriving at the conclusion that the state, in conducting something according to the rationale presented to the court by the defendant so far, that the state never intended that they find out about in an effort to cause them to do something. I don't know how those two can be squared with one another. So we would ask that the court deny the motions.
Let me give you an example. In the, the Rust shooting, that Brady violation Well, the judge there didn't say, well, you have it now. No. The Brady violation was in the attempt to conceal it from the defense, having a week-long, or at least a few days of testimony before everything was halted. It is prosecutorial misconduct either way. The Brady violations, if it's concluded as a Brady violation, you have to make a ruling on that, regardless if they have the information now.
For mistrial based on the state, based on anything, I'd point out that this is not the first or the second or the third motion for mistrial. The state has objected every step of the way. We continue to object to a mistrial. Again, if they feel they're winning, let's keep it rolling. And we would ask that the court just deny it. Of course, the court is aware that the issue here is not whether anyone acted improperly, but what objective the prosecutor is trying to achieve. It does not make sense to assert on the one hand that we want you to not ever learn about it, and on the other that we are intending that you be goaded into an act by our doing it. Okay. So thank you.
Yeah, and as MD says, that Brady violation in the Baldwin case was not even a material issue. In this case, this Woody is their star witness. And they colluded together and hiding the transcript from the defense, which they would have needed in their cross-examination. That demands a ruling on that issue. Oh, this is fury.
There are issues here as to whether people acted improperly. Perhaps that does not go to the goading, but I don't want to, it's clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights. He has been locked up in Rice Street for 22 months. I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. I have no interest in retrying this case, Your Honor, and we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
All right, thank you. And I don't know whether this was, I think this was Mr. Nichols' reply to the state's response. So I don't know if it was with regard just to Mr. Nichols' own motion for mistrial or also Mr. Kendrick's motion for mistrial, but I think the argument is applicable to Mr. Kendrick's as well, so I'm going to address it right now. Mr. Nichols argues that the state says that the defense's characterization is a mischaracterization of what happened in the ex parte, but does not offer their own characterization, and therefore they essentially aren't opposing it. And I should just take as fact everything that the defense said. And I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, "The hearing in chambers was proper," unquote, and then quote case law. So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper. So with regard to that issue, I'm not finding with Mr. Nichols. Now, I am going to, in the context of taking under advisement the other motion that we talked about before, take under advisement the concept of whether what occurred in chambers was coercive, and if so, was coercive to the extent that under the cases like, I think, Wynn and Webb, it requires a mistrial. Because I think the concept generally was before Judge Krause, but not in the kind of detail that it is right now. So I do think that that is something that I can take into consideration and will take into consideration, and y'all both briefed it, and so I'll get the ruling to you. As with regard to the propriety of the ex parte itself, we've kind of already talked about, I don't think that was the actual basis of Judge Krause's order on the recusal, so I will endeavor to make a substantive ruling on that as well. So that's another one that I'll probably give you my ruling tomorrow. So,
Yeah, I
making myself a
wouldn't be
note.
surprised at all. Not
All right,
as
now
active
to Mr. Nichols' motion for mistrial, which, in addition to everything else
Okay, now
that's in
let's
Mr.
go to Mr.
Kendrick's,
Nichols.
essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible. And Mr. Harvey, I know,
I apologize. Can I interrupt you again?
yes,
Thank you. I do that with, a smile and a request for permission.
okay,
Again, I think there are several other mistrials with prejudice that have not been heard by you, and that would include Mr. Williams filed on July 10th of 2024, entitled in part, Motion for Mistrial Based Upon Judicial and Prosecutorial Misconduct and thus bar retrial. Mr. Shart.
Okay, what Mr. Nichols is doing here is because Bruce Harvey, the legend, kind of sees the writing on the wall here. He does not want his motion to be heard before all other motions for mistrial with prejudice is heard. Because if she grants his motion for mistrial, then it's just a mistrial. So good on you. At least that is my interpretation.
On behalf of Mr. Jackson, also has a mistrial with prejudice pending that I don't believe the court has heard. And again, I think in seriatim, if you decide on all of those, then I'll come behind these brilliant lawyers.
all right, I appreciate it.
follow up.
So with regard to Mr. Williams earlier, prior to the, July 9th. Honestly, I don't know that I saw a motion to recuse filed July 9th, but when we talked about all of the pending motions before, there was the July 10th motion for a fair trial and for mistrial and prosecutorial and judicial misconduct. That's one of the first motions I took up today. Is there another one?
What?
Yeah. Well, I did. That was one of the first ones. Is there another one other than that? Yes.
Mr. Williams is not asking for a mistrial. If you grant a mistrial, then that would be over objection, and that if you grant, I joined in the goading. I think it's a two-step process. You grant a mistrial or deny a mistrial. If you grant a mistrial, then there has to be a conversation about a plea and bar. So I'm joining. If you grant it, it'll be over objection, then I'm going to file a plea and bar. So I was just upfront. with the
Okay.
court. So
But
you are
with regard to anything, is there any motion for mistrial filed by you on behalf of your client other than the kind of, not really omnibus, but multifaceted motion you filed July 10th that was for a fair trial to get all the ex partes for mistrial based on prosecutorial and judicial misconduct?
on Friday, July 27th, I filed a response to the state's, you called it a gag order. And in that, the second part, I also filed an adoption that if you declare a mistrial, it will be over objection. And then I will be raising plea and bar because it would be, the only reason to declare a mistrial is because the defense was goaded into it. So that is it. So.
Okay. All right. So Mr. Harvey, I don't think Mr. Williams has another one. And then Mr. Shart, on behalf of Mr. Stillwell,
July 23rd at 3:07 p.m., a motion for fair and constitutional trial. I have a lot to say.
yeah.
And I believe I'm similarly situated to Mr. Steele in many ways regarding that, because I do believe we're being goaded into moving for this trial. I do believe that case law supports that conclusion. I do believe that so much in this case has happened that has broken the case. I believe, and I'd love to be able to argue all of that, but I am not specifically asking for a mistrial unless jeopardy attaches.
Okay.
And so that's where I'm at. I'm happy to argue that. I'm happy to argue that before or after Mr. Harvey or Mr. Steele.
Okay. Give me just a second.
I hate to say it, but it seems like this judge made up her mind before she went into court. Now, that is not unusual at all. Not unusual at all, that. But sometimes, for instance, it's like with closing arguments. You rarely win with a closing argument.
Sure. You know what? I
but
need
you
to
can
find
lose with it.
the motion that was just referenced by Mr. Shardy. Anyway, why don't we've been going for a couple of hours. Why don't we take a 5 to 10 minute convenience break? All right, we'll be in recess.
Okay. And I was 4 minutes behind. All right. Let's see. Where were we before we ended? Hold on. Yeah, we were talking about Mr. Nichols' reply to the state's response. Dun, dun, dun. Let's see here. Because I really, really like this one. And hello, folks over at Rumble, by the way. Yes, I am also doing this via Rumble. So, okay, let's keep where we started. We were around here. Here is the Nichols moves this court to accept the arguments as made by the defendants because the state did not proffer any argument in its own in rebuttal. Now the judge already said that she believes they did. Nichols moves this court to accept all the legal basis offered by the defense as grounds for a mistrial because the states did not submit any legal arguments to the contrary, which he says they just stated their opinion, not their legal argument. But it seems like Judge Whitaker says, well, that's enough. Nichols urges this court to take note of the seriousness of the defendant's motions, which specify in detail the events which have acted as denial of the rights to a fair trial. This was followed by the state's cynically dismissive response, which seems to consider the right to a fair trial as a trifling afterthought, rather than a pillar of the criminal justice system guaranteed by the Constitution of the United States of America, the Georgia Constitution, numerous statutes, centuries of case law, and the rules of criminal procedure. Now, I really, really like Mr. Harvey. Really, really like. The lack of regard by the state for the fundamental issues of fairness is strongly evidenced by the paucity of the state's response, and we implore this court to take notice. A fair trial is not optional. It's foundational and mandatory. A trial is not considered fair simply because the state says so without explanation. The defendants in this case were in fact goaded into moving for a mistrial as described in their motions. This is not refuted by the state. We move this court to grant a mistrial on that basis. Constitutional implications and violations. Now, regarding the goaded argument, it seems like the judge doesn't agree. And it's not much we can do about it. Constitutional implications and violations. In Mr. Nichols' motion for a mistrial and objection to the mid-trial substitution of the trial judge, this will probably be the next part that they argue in the trial, in this hearing. Nichols further relied on his right to a fair trial under the 6th and 14th Amendments to the United States Constitution, as well as the concomitant provisions of the Constitution of the state of Georgia. The state responded by arguing that his claim was made and rejected in McIntyre v. State. First, in McIntyre, the Supreme Court of Georgia specifically said, we assume, for purposes of this appeal only, that these rights are implicated by the mid-trial substitution of judges. After assuming that constitutional rights are implicated in the mid-trial substitution of a trial, the court went on to hold that the defendant in that case had, quote, not shown that he was harmed by the substitution, and therefore, under the circumstances of that case, the procedure followed in the trial court does not require reversal of the judgment of conviction. The court also stated that, quote, in Georgia, the temporary absence of a trial judge without suspension of the trial is not a basis for reversal unless the complaining party shows prejudice resulting from the absence. The state's comparisons of the case at Barr and McIntyre is entirely unavailing. Yeah, the state, their cases, they showed 3 cases. One where a juror got injured, so they had a break. One when the judge fell ill and had to be replaced, and that took a break. And the third was a judge whose grandson passed away, so we had to go to the funeral. In this case, this pause, the stay of the proceedings, is because Judge Glanville did a misconduct that got him thrown out from this case. And now, in a few days, in a week and a half, the jury has been gone from the trial for 2 months. So they're completely different cases, completely different. Let me check on the... Nope, they are still not back. In McIntyre, the trial judge's absence was to attend to his grandson's funeral. Here, the trial judge is not absent for purposes of a finite leave. He was recused. In McIntyre, the court specifically took note that the trial was not suspended. Here, the trial was suspended for over a month and counting. Dissimilar to McIntyre, Nichols has not been convicted and has been on trial for over 19 months prior to the permanent removal of his trial judge. Nichols' trial is the longest trial in Georgia's history, which includes over 6 months of testimony, some of which was conducted by the later removed trial judge after motions of his recusal were filed, which was subsequently granted. Further, in McIntyre, in the concurring opinion, the court noted the defense's limited request for review of the previous proceedings, included no further discussion or request pertaining to the matter. In the instant case, Nichols specifically objected to the substitution of the trial judge mid-trial and has submitted reasons why the substituted trial judge needs to be familiar with the entire record. The impracticality of this requirement and the harm that is caused by the substituted judge's lack of familiarity with the entire record. The state concludes by noting that in McIntyre, the court specifically referenced People versus Espinoza, in which the Supreme Court of California held that the substitution of the trial judge for the defendant's guilt phase did not violate his rights. In stark contrast, in Espinoza, the trial judge was present until after the jury reached a verdict. The defendant's application for modification of the jury's sentence of death was the matter considered by the substituted judge, replacing a seriously ill judge after reviewing the transcript of the trial proceeding which occurred before his substitution. None of these facts exist here. Number 3. Directed verdict and other decisions to be made by the trial judge. In the state's response, the state seemed to acknowledge that directed verdicts are available, but ignores the inconvenient fact that familiarity with the record is a prerequisite for the court to make that decision. Neither does the state explain how the court will make
is that there's been kind of a lot of up and down and back and forth and in and out, and that is distracting. So I know there may be times when you need to step out for a particular reason, and that is fine. But let's try to minimize that, because if it gets too distracting, I'm going to have to ask you to step out until all your business is taken care of. Okay, so you got to go out, but then it can't be a up and down every 5 minutes thing.
I suspect that the audience here includes, but not limited to, the helpers of the defense and to the prosecution, because internet doesn't work more or less in the courtroom.
All right, thanks. Okay, so Mr. Short, yes, I saw your motion for a fair trial, and the reason I didn't register it as a motion for mistrial is because it's essentially not. It's saying if you grant a mistrial with prejudice, we're in on that. But otherwise, we'd like to, even though we think this trial has been a disaster, we would like to keep going because we think we're winning. So you asked that it be a constitutionally fair trial, and I guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial.
They are not talking about when you took over. They're talking about the entirety of the trial. What? So your guarantee that you will conduct yourself properly going forward has nothing to do with this motion. Oh, God.
Under the Constitution.
For instance, if you drop a glass of water into a bucket of shit, it doesn't become no shit. It's shit, but runnier. This is the trial we're talking about here. You cannot have a fair trial because the first 19 months of it is unfair.
Of the state of Georgia, the United States, and the laws of our state. Okay, that is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
I appreciate that. I guess my concern is that all this is not under your control because you're taking.
And I can hear you fine, but I don't know whether my co-reporter can or not. You can either come up or you can pick up your mic if you're just a long way away.
I guess my concern is that I have no doubt that you will do everything in your powers. I just don't know if at this point, if it's within your control to ensure that we receive a constitutionally appropriate and fair trial at this point based on what's happened previously. And, you know, I do have cases regarding the concept of goading.
Okay.
But I'm trying not to step out of turn. I know that I am stepping out of turn a lot this morning, but I'm trying to not step out of turn. If you would like those cases.
Yeah, I'm happy to take into consideration anything that y'all want to offer that is on point.
Go.
Why, you accepted crap from the prosecution that wasn't on point. Why do you have a higher standard from the defense?
May I approach?
Yes. Can't really get to me, but you can get to my staff who can hand it to me. Thank you. Oh, yeah. I've seen web-cited, and I'll take a look at Jackson and Wilson.
Jackson. Oh, did I not give you Anderson?
No.
Oh, I'm sorry.
Thank you. Okay.
And Your Honor, I believe that those cases stand for the general proposition combined. Each of them are a little factually different,
Okay.
but they stand for the proposition that the trier of fact can consider certain factors. Of course, the difficulty in determining if someone's goaded someone else comes down to intent. Typically a district attorney or a prosecutor is not going to take the stand and say, I intentionally goaded someone. So you look at objective facts. And these cases stand for the proposition that you look at how basic the rule that was violated is, the experience of the prosecutor. In this particular case, this is a big county. The prosecutors involved in this case are a chief deputy with the district attorney's office and a deputy with the district attorney's office are the two prosecutors that were involved in the ex parte meeting. You look at the evidence of the case, and I know that this is another area where you're hamstrung a bit because you haven't been sitting to hear the evidence. But I concur that the whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that their key witness, and without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked and they needed a mistrial. The trial was not going well. The previous witnesses that have testified, it's been again, I know you haven't been here, but we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment by inconsistent statements and contradictions. So, and that's another factor that those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's attention.
All right, I appreciate it. Thank you. All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial preceding yours that we have not discussed. And
now it's Harvey's turn.
am going to address a few of your issues really, well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings, and I have no idea where you got that from, because I certainly know.
You said that on the meeting where you did all the things, that you do not intend to go back to prior rulings. I believe that's almost an exact quote. I do not intend to go back to assess Judge Glanville's prior rulings. But in order for you to do some of the things that is required of you by law, you have to.
Never said that.
When we were here last week, and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying, I'm not going to revisit certain motions, or I'm not going to go back to hear those, that was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, I'm going to deny your motion, for example, for a severance, for a 105 instruction at this point. But that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court, understanding the cumulative nature of what has happened
and how it would factor into your particular decision
Okay,
at the next point
Okay.
in trial. Does that,
that
is
makes
that
a little
clear?
more sense. I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, as soon as she finishes it. You all have, some of you have already pointed out, particular things that while not the official transcript, I can review on YouTube, and I've done that to the extent it has been relevant to these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
Well, okay, yes, and okay, no. Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up to where we are at this particular point after 9 months or thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it. But you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it. But now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice, their actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, just reading a dry transcript is insufficient. Every court from the US Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer. You cannot get the context. You cannot get the understanding of a witness unless you're there to view that witness. So I start from the premise that no matter how hardworking you may be, and I think you're a very hardworking judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that should stand, and I'm going to grant. I mean, it's entirely in your discretion, and that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the trial court must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial, sit as the 13th juror. Don't think he can possibly catch up to that extent. Nor do I think that, based upon the cumulative nature of Judge Glanville saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction, which the court said, I'm probably going to give that at the end of the trial, but I don't think it's necessary to give it now. So,
Okay,
all of those.
I understand. And I don't really need to hear from the state on this one. With regard to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule on the motion for directed verdict.
No, you can't. No, you cannot make that determination on only the evidence presented once you sat down. You have to do it on the entire presentation of the case from the prosecution. That's not how it works.
Assuming we get there. But if not, I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment.
No.
And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times, it's not routine, but it happens when a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review, when it is a different judge than the trial judge. So, if and when we get there, I will consider whether anything ought to be granted as a 13th juror if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis on which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything that ought to be taken into consideration if and when you make that motion again. With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit.
Yeah. That line was Judge Glanville's favorite line to say. I leave it to the appellate court, which was exactly what he said about the ex parte and the transcript. He was prepared to keep everything a secret from the defense and then release that record after the trial concluded.
Something. Okay.
To make sure that my motions were also based on the underpinning constitutional rights, both federal and state. And I don't want the appellate court to say, hey, she didn't say anything about that. But I want to make sure that those bases are preserved. Although I disagree strongly with your ruling, I'm still here.
All right, understood, and it is so noted, and obviously it's to whatever it is that you have, any of y'all have set forth in your various motions. All right.
Yeah, that thing, leaving it to the
All right,
appellate court, that is such a bad cop-out. That is just a judge being too much of a coward to make a proper decision. I loathe cowards. Cowards should not ever be judges. Leave it to the appeals court. No, make a damn ruling and make it correctly. Don't punt it.
I think we all already sort of agreed that we need to redo everything that happened post recusal motion on June 12th and the details and logistics
We'll
of
make a
that will
proper
take
ruling
up
tomorrow, but
probably tomorrow. But that motion itself is granted.
yeah, the motion is
All right.
granted
A
regarding
lot of what comes next
the
is
do-over of
evidentially
Woody's testimony.
specific. And before we get to that, I know that there are some outstanding bond motions. So Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that whichever, I don't even know who took up the bond to begin with, but another court has already considered all of those, the Ayala factors. And you don't present changed circumstances. You just essentially say this call was wrong to begin with and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So that motion is denied.
Can I address the court?
Do you have changed circumstances?
Yes.
So, okay, go ahead. There weren't any in your motion.
Mr. Williams has been in custody since the 9th day of May of 2022. This is in my motion. It should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy, because if he flees, the case goes on because it's mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the Ayala factors. And so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew to the
All right. Well, that may or may not be in a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an Ayala type change circumstance.
Okay.
So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Even though potentially it was not done by a fair tribunal.
I don't, so, all right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, you know, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts.
Yeah, Judge Krause knew what she was doing by putting in that despicable little sentence in her finding, in her ruling. She crippled the defense and the court from making an actual finding. Judge Krause, you belong in jail.
And information when he denied the motion to recuse, and that was not what the rules require, and so recusal was necessary. But she even, I think, went on to say, but even with that, I don't, you know, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Then I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration. But I understand what you mean. All right, Mr. Huey has a motion for reconsideration of bond with asserted changed circumstances of the ex parte being a critical part of the trial that he was excluded from and having been held longer than he otherwise would have because of the delay resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carrington Matthews for Mr. Marquavius Huey. I cite for the court Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for a bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information, the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now with the state, right? With a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence when the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for bond is made, that the candidate
based upon the change in circumstances, would be a good candidate for a bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of
Mr.
Georgia?
Matthews, that is not an appropriate consideration for bond.
I would ask,
Period.
understood, Your Honor. I'm asking the court to look at the resources that are required to have Mr. Huey here every day. That's all I'm asking the
Not
court to
appropriate
look at.
consideration for bond. All right.
So essentially, Your Honor, I'm asking the court to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court
All right.
based on judgment calls.
Okay.
So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial, if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law. And also, I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state, 298 Georgia 438, a 2016 case.
What was that? Sorry, is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial,
Okay.
so forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor,
Okay.
which we are alleging is a change
Okay.
in circumstances, a change brought about by the court and not by Mr. Huey. And we believe that that month and a half delay where he's had to sit in the jail, we're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor.
Okay.
Respectfully.
Thank you.
Thank you, Judge.
All right. So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper. It was that Judge Glanville.
How the flaming fuck does his conduct towards the defendants, arguing his own case, how the fuck does that not make him biased? That's plain horrible. I had such hope for Judge Whitaker. She may be proper, she may be effective, but it seems like she is the exact same pile of garbage as the rest of the judges in this fucking county.
Engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration, in the defense's view, has become biased, but
he was thrown
that,
out because
in the same way
he
that I
made
said
such
to
an
Mr. Steele with
outrageous
regard to Mr. Williams.
decision to keep this trial going, knowing he did that against the rules, just to keep the trial going.
If I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bonds. I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond. He asserts changed circumstances that essentially this case has taken way too long, which
Well,
I
Your Honor,
don't
could I-
necessarily disagree with, but
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
all right, I will do that. I
Thank
think
you.
that would be more appropriate. Thank you. Okay.
Good call by Mr. Weinstein. Yeah, but she's arguing, the judge is arguing he was not recused because of bias or his conduct in the ex parte meeting. It was his conduct during the recusal of him. And for me, that is, if he isn't unbiased, why did he try to hide this from the defense? If he's not unbiased, why did he so desperately want to continue to be on this trial that he knew he broke the rules? There's no way he didn't know it. He quoted the rules, some of it at least, which is insane. But he was so desperate to have this trial continue that he denied the motion of recusal and let the trial continue. How does that not show bias on its face?
So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion for, it's entitled for reconsideration regarding certain hearsay statements. But given that we've all acknowledged we're redoing Mr. Copeland's testimony, it's not even really reconsideration. It's consider it anew as we go forward. So I'll hear you on that.
I'm so disappointed.
Thank you, Your Honor.
I'm not surprised, but
Before I get started, could I hand over a case? It's actually the Scudder case that Mr.
Okay,
Matthews
sure.
referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may in fact not be a motion, but
For a fair trial?
yes.
Okay.
But in the state's argument against Mr. Kendrick's motion, they're relying on King. I
Right.
would invite the court to look at the facts surrounding this ex parte meeting. It's clearly distinguishable in every
Okay.
way from King when you look at the facts. And I would just remind the court that King was involving a request, giving the court background facts to show that granting immunity to a witness was in the interest of the public.
Okay.
That had already been done in this case the Friday before. So So it's completely different when they had the ex parte meeting on Monday, and I believe Scudder is
Thank you.
more appropriate
All right.
to consider, and it's much more analogous and on point to what happened in this case. And of course, Scudder points out the problems with such a meeting and held that it was improper. Regarding this issue of Mr. Copeland, I appreciate the court correcting my label of what this really is. I agree that it's a consideration anew, and we had prior discussions about it. There was not a written order to this point.
And do you want me to take a look at the original consideration? If so, y'all need to point me to where I would
I
find it.
don't know where it is,
Or we
and
can
this is
just
not.
start over.
I don't mean to sound like I'm being smart out here. It was discussed. Some of my motions were brushed over so quickly. I think I assumed that I had lost that motion in front of the prior trial judge, and I'm not sure if it was actually a ruling or not. I'm trying to, if I could go back to my seat for a second. I just
Sure.
Yeah. Hello, Gwendolyn. Gwendolyn says, this definitely has not been a fair trial so far. It doesn't look like it's going to get any better either. Procedurally, it will be a lot better. The pacing will be a lot better. I don't know about the rulings. We don't know how she will rule on evidentiary facts going forward.
I'm gonna give you something else.
But as I said earlier, she might be a glass of water poured into a bucket of shit. It's still a bucket of shit. No matter how good she conducts the rest of the trial, it's still shit. Hit that like button, folks, because my comments just
This one.
made this stream just made this stream what do you call it? Well, I'm not any ads. I won't get any.
And I've also provided
This
copies.
stream has been demonetized.
Okay.
That is the word I was looking for.
Factually, what this is about, Your Honor, is based on statements made by Kenneth Copeland, out-of-court statements.
Mm-hmm.
I think the understanding where we are and the understanding of the facts is we know it, or the alleged facts as we know it, is that Mr. Copeland claims that he was in Mechanicsville on January 10th, 2015. This involves the alleged murder of Donovan Thomas, for which Mr. Stillwell and Mr. Kendrick are charged, and is part of this RICO indictment as well. He alleges he wakes up in the middle of the afternoon, is in Mechanicsville, maybe 300 yards from the scene of where Mr. Thomas was shot at the Green Store, off of McDaniel Street, at the corner, I believe, of McDaniel and Glen Street. And Mr. Copeland tells the police that he is trying to find his friend, Demekion Garlington, and trying to figure out where his friends are, because he woke up in the middle of the afternoon. And he allegedly calls Mr. Garlington and travels down to a McDonald's on Cleveland Avenue. In these pretrial statements, he claims that Mr. Garlington was pulling into the McDonald's as he was pulling in, and essentially in pretrial statements, he says Mr. Garlington and a gentleman named Mr. Demise McMullen, who's also known as Nard and is also charged with the murder of Donovan Thomas, approached the car. Mr. Garlington gets in first and quickly indicates to Mr. Copeland, before outside of the earshot of Mr. McMullen, they killed Nutt, essentially, and allegedly points to another car that is a white small SUV type car that contains, according to the story, Mr. Stillwell, Mr. Kendrick, I believe, Mr. Williams, Mr. McMullen was at one point in the car. and another gentleman. The point is, it's a quick statement, and it's they, and he points to this car, according to Mr. Copeland, out of court. And this was June 10th, 2015, when Mr. Copeland said that.
Yeah,
There were-
and I have listened to and read the transcript of that interview.
Okay,
So I'm familiar with it.
and just to add context, there were several interviews with Mr. Copeland prior,
Right.
and he never made mention.
This
of
was
this.
the fifth one.
So, and also to add context, Mr. Garlington is called in to an interview. He's subsequently interviewed. He denies making those statements. Also to add context, Mr. Copeland on the stand acknowledged that he made those statements to the police, but denies that they were true. And although he didn't specifically say it, he seemed to be alluding that he no longer has the same relationship with Mr. Garlington now as he had back then, because Mr. Garlington wouldn't lie for him. It wasn't directly said, and I'm sure we'll come up and cross, but putting the dots together, Mr. Copeland was in legal trouble, wanted Mr. Garlington to lie for him, to verify this lie that he was telling the police. Mr. Garlington wouldn't do it, and it foiled Mr. Copeland's attempts to get out of jail. That's the context behind all this. But the question is the admissibility of this statement, they killed not, and to the extent any follow-up conversation about that incident that Mr. Garlington allegedly said to Mr. Copeland. Mr. Garlington is charged in this indictment. He has a Fifth Amendment right. He's not on trial with us. I have no information that suggests that he's going to be testifying in this case. So he will not be testifying. So the state is attempting essentially to ask Mr. Copeland about statements he made to the police of what Mr. Garlington told him, because there's no indication that Mr. Copeland himself has any firsthand knowledge or is a witness in any of this. Now, I have a separate concern about the way they're not laying the foundation for a prior inconsistent statement to play the videos, because Mr. Copeland is in fact acknowledging that he told the police. He's not denying making that statement. He's just denying the veracity of that statement. That being said, the statements themselves, how are they admissible? Because they're clearly hearsay. Garlington to Copeland. Copeland without firsthand knowledge. So the state has always taken the position, as I understand it, that these are statements by a co-conspirator. Thank you. They've always taken a statement that they're statements by a co-conspirator. In their filings recently, and I don't want to misstate this, they may have made this claim before, so I'm not going to say it was the first time to make this claim, but I noticed in their filings, they argued in the alternative that they're statements against penal interest as well. And they've provided cases, and I have just handed up my cases regarding co-conspirator statements. Of course, and we're talking about hearsay and the confrontation clause. It seems to me their main reliance is on the Kemp case, where the Kemp case, as they want it to be understood, is that idle chatter or narrative of past events do not further a conspiracy, but narrative of past events are admissible if they serve some present purpose of the conspiracy, including statements made to solicit membership or participate in the conspiracy or to promote cohesiveness among or provide reassurance to other conspirators. And the reason I filed this motion is because in all prior discussions, the trial court completely glazed over the furtherance. I'm focusing on whether these statements further the conspiracy. Okay, the state's cases do not apply to this situation. The difference, and I'm referring to the Kemp case, United States v. Flores, which the state relies, United States v. Santiago, and US v. Holt, all in their filings. There's absolutely no indication in the record in these statements that the alleged declarant Garlington was attempting to solicit the membership of Copeland in the conspiracy in any way. And I understand the states in the case law, some of the cases indicate this, that you have a conspiracy, you got a small conspiracy and a large conspiracy, and statements in furtherance of a conspiracy could be furthering the large conspiracy. Okay, but soliciting membership, there's been no allegations whatsoever by the state. In fact, they've we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. They've fought to say that Kenneth Copeland had nothing to do with that conspiracy. So there was no solicitation there's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. In fact, that had already occurred at the time that these alleged
We'll just break off it. I will continue this stream until lunch. Then I will continue what was said during the afternoon part of this hearing tomorrow, and I will continue that way. Because as I see now, with how the judge acts, I don't think this hearing will take this entire week. So she will make the mistrial ruling tomorrow. That I will cover live. I believe she will do that directly in the morning. But yeah, so I will continue this stream until lunch, because I don't have enough material for you for an entire lunch break. If she takes lunch, that is. If she doesn't, then I will just continue, just so you know it, folks. And when I break off, I will send you all over to Cat Not Williams.
Comments by Mr. Garlington were made. And if the argument is, well, they were trying to solicit his membership into a larger conspiracy, the YSL conspiracy as a whole. Mr. Copeland, according to the state, from the very beginning, according to their expert, Investigator Belknap, according to everything they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland from 2012, 2011, 2013, well before this date, where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy according to the state.
Okay, let me ask you this. So a part of the cases that the state cited, I mean, it may be that part of it was one way you can find this as a co-conspirator exception is soliciting membership, but another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang. So can you address that?
Well, they have the burden of proof by preponderance of evidence to show that this has been furthered. There's been no evidence. Again, we're seeing pictures from over the years. There appears to be complete cohesion. There's been no evidence that this was done, if it happened at all, which my stance is it didn't happen, but assuming that the statement was made by Mr. Garlington to Mr. Copeland, his brief statement, I think we're really stretching where the exception is essentially swallowing the rule. If we just say, well, a statement about past events with absolutely no indication that someone said, hey, this is what we need to do. We need to be quiet. We need to do this. We need to do that. There's no indication that Mr. Copeland was instructed to do anything. Mr. Copeland just drove where he wanted to go afterwards. Now, I will say, and I'm sure the state's going to point this out, that people on the street apparently thought Mr. Copeland was involved and began allegedly shooting up houses that he was associated with, but that has nothing to do with the purpose of the statement that allegedly Mr. Garlington made to Mr. Copeland. So there's absolutely, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement and just assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with? Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything. The story that comes out through past statements are Mr. Treadwell takes a car somewhere to get rid of a car, to get rid of guns. Again, I'm not saying these are true statements, but that's what comes out in the discovery, and that's what comes out in other people's statements. Mr. Copeland has, it's completely devoid of anything that Mr. Copeland was asked to do. As far as also fostering cohesiveness, Mr. Copeland himself said that Mr. Garlington at the time was his best friend. So I'm not sure. In the United States v. Flores case, they talked about cohesiveness and cohesion within the group. And there was a situation where one individual, the declarant, was talking to another individual that didn't know. So you got the declarant, who ends up, and then another individual who ends up being the witness. We'll call him the third party, and then you have the defendant, and the declarant is telling the witness, "Hey, let me tell you about the defendant. He's a solid guy because this is what he did, and we're all one cohesive group." But the witness and the defendant were not close. They didn't really know each other. So the middleman, who ends up was the declarant, is kind of informing one person about the other and saying, "Oh, he's solid. We can be cohesive." In this case, Mr. Garlington and Mr. Copeland and Mr. Stillwell all knew each other very well. And that's come out in testimony. That according to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. So I think it's distinguishable in that aspect as well. US v. Holt, I'll just point out also, with all my other arguments, there's no indication in that case. It talks about keeping a co-conspirator abreast of the situation. There's no indication that Mr. Copeland needed to be kept up abreast of the developments at the time. Mr. Copeland was not summoned to do anything by the group. Mr. Copeland called Mr. Garlington, wanting to find out where he was. So it wasn't a situation where the group, assuming these statements were made, called Mr. Copeland to bring him in. "Oh, can you pick us up? Can you do this?" Mr. Copeland reached out to them. And also, I'll point out that US v. Holt was argued under or decided under the plain error standard, because the trial attorney did not object appropriately. I have the four cases I handed up: US v. Blakey. Well, I'm sure the court will read the cases, but State v. Wilkins I thought was particularly informative. It's a Georgia Supreme Court case. Trial court made a pretrial ruling excluding incriminating statements made by the co-defendant had been tried earlier. Trial court held that while statements were made by a co-conspirator, they did not further the conspiracy, and the trial court did not abuse its discretion. And it goes through all these different statements that the declarant co-defendant made that were basically spilling the beans and did not further the conspiracy in any way. State v. Lane, same thing. In that one, it's interesting. The appellate challenges the murder conviction, and the trial court granted Lane a new trial. The allegation was, the appellee, the defendant, hired Stallworth to kill a gentleman named Mr. Perez. A witness named Thompson testified that Stallworth told her about the plans to hit a lick before the killing, and then afterwards said that Lane did not pay him because he killed the wrong guy. The trial court initially at trial let the statement in, but then at the motion for new trial reversed itself, saying that in no way, in no stretch of the imagination was this statement made in furtherance of the conspiracy. A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy. The state points to no evidence that suggests that by these statements, Stallworth was seeking to solicit the help in conducting the scheme or concealing its existence when he made those statements to his girlfriend. So those are the cases that I rely on. I also provided Stafford v. State, which is a little different because that was made to law enforcement. It supports my proposition generally, but it's a little different because it was made to law enforcement. Would you like me to address the statements against interest while I'm up here?
Is that in this motion?
Well, no, I understood the state's reasoning for the admission of these statements.
The penal interest? Yeah,
Yes.
Go ahead. Yes.
So I'm confused on how this is against Mr. Garlington's penal interest to say they killed someone. It's a hearsay statement that inculpates the accused is admissible if the declarant is unavailable. Okay, I can see that. The statement so far tends to subject the declarant to criminal liability that a reasonable person. Gotcha. I'm sorry. That would subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true. And the statement is corroborated by circumstances clearly indicating its trustworthiness. My main objection is number 2, although I do believe that the statement is not corroborated either. But prong 2, it was not the type of statement that tends to subject the declarant, in this case, Demekion Garlington, to criminal liability. He said they did it. I don't know how that could be a reasonable person could, how it could be said that a reasonable person would feel that saying they did it would put that person in legal jeopardy. As we know, as the pattern charges tell us, knowledge of a crime, mere presence, but certainly knowledge of a crime is not enough to convict anyone. And again, he did not say that he had any part in it. He did not say he played an active role. Additionally, Your Honor, I would point out the Williamson case that I provided. And the Williamson case is, I believe it stands for the proposition that if you find any part of Mr. Garlington's statement to be self-inculpatory, which I don't believe it is, Williamson dealt with a situation where within a statement, there's inculpatory and exculpatory segments of the declarant statement. And Williamson says you have to deal with the pieces of the statement individually, and you just can't say, well, there is some inculpatory parts of this statement, so therefore it's all allowed in. You have to excise out the self-exculpatory areas within the statement and the neutral areas within the statement. It says 804B3 only extends to self-inculpatory statements and not self-exculpatory portions of a larger inculpatory statement or to aspects that are neutral as to interest. Self-exculpatory statements are exactly the ones which people are most likely to make when they are false and mere proximity to other.
In layman's terms, the case he's citing more or less says gossip is not evidence unless the person who says it indicates they were a part of the crime. That is as condensed as I can say it.
Self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's Williamson v. State 512 U.S. 594, 1994. So if there are, which I don't believe there are, any inculpatory parts of Mr. Garlington's statement, the exculpatory or neutral aspects of that statement need to be excised out. And I'll point out that if you listened, and I know Your Honor did listen, but I mean, I've listened to these statements 15 times, 20 times at this point. It's very unclear to me where the source of some of, we're assuming a lot of it's coming from Garlington, but it's really unclear where Mr. Copeland is claiming to have received some of his information and when he received some of his information. So that makes this task difficult. I think that absent a showing that the state can meet their burden under 801D2E or 804B3, that none of it should be admitted. But certainly, if we were going to admit some of it, we would have to excise out the parts that are not self-inculpatory, including, but not limited to the part where he's pointing at other individuals and say they committed a crime. So those are my objections. I think if they come in, that it violates hearsay as well as the confrontation clause.
And what's your confrontation clause argument? Because we haven't really touched on
Well,
that so
because
much.
Mr. Garlington's the source of the information and he's not going to be subject to cross-examination. He's not testifying.
All right.
So thank you.
Thank you. Who's arguing this for the state?
And now here's Miss Love. Satan Carlos going to lie to the court. Hopefully, my hope here is, please, Judge Whitaker, for the love of all that's holy, look at what the law actually says, what the case law actually says. Don't allow Miss Love to nag your ears off.
Judge, I will, of course, stand on, not stand only on, but stand on the response that we have filed. I would point the court's attention starting off to page 3 of our response and the second full paragraph on that page, Your Honor, where we are giving some facts of the case wherein it's already been shown at trial that a few days before the murder of Mr. Thomas, Mr. Copeland said that he was with Defendant Williams when Defendant Williams rented an Infinity from a rental facility at the Atlanta airport.
That Infinity is not the same light-colored car seen on the surveillance camera. I could take the stand on that because the grille on the passing light-colored car is not the same as the grille of an Infinity.
That same Infinity, we allege, was utilized in the murder. Evidence at trial has already proven that Defendant Williams did in fact rent an Infinity Q50 on January the 7th and returned it on January the 11th. Testimony at trial has already revealed Mr. Thomas's participation in Mr. Thomas's standing as a high-ranking rival Inglewood Family Blood gang member to the YSL criminal street gang. The week before, as Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial by Mr. Thomas's.
How is she supposed to make a ruling when they assert testimony? Now she needs to listen to that testimony. But, I mean, she has the transcript, but the transcript is not the same as testimony.
His brother, Kelvin Watts. And in the early morning hours after the murder, multiple YSL gang members, including Mr.
Slow
Copeland.
down.
I apologize.
And
Including
y'all start reading instead of talking. Speed up. All right, go ahead. So in
the early morning hours after the murder of Mr. Thomas, multiple YSL gang members, including Mr. Copeland, Defendant Williams, Mr. McMullen, Demetrion Garlington, Diamante Kendricks, and Shannon Stillwell fled to Miami, Florida. And
That hasn't been proposed in trial, has it? What do you mean, fled to Miami? Didn't Mr. Williams have a concert there? That's not fleeing to Florida. That's making the appointment. Yes, it is. Yeah, I mean, I was reacting to fleeing to Florida. They didn't flee. They had stuff to do in Florida.
after these members of YSL returned to Atlanta, there were a number of retaliatory shootings between YSL and IF gang members. So just to sort of encapsulate that, all of that, when Demetrion Garlington alerted Kenneth Copeland that they just killed Nutt, he was alerting Kenneth Copeland to the fact that a rival, a high-ranking rival gang member has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
Excuse me, I apologize.
Yes, sir.
A lot of this is not, and I put in writing, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown or will show.
Okay. So you, Ms. Love, are presenting this as what the evidence has already shown.
Part of it. Not
So
the part that I'm saying now, I specifically say when I mean to say that the evidence has shown.
okay, so the evidence has shown that Thomas was a high-ranking
Yes.
person in a rival gang.
Yes.
That the week before Mr. Copeland was assaulted by Thomas's brother.
Yes.
That in the early morning hours after the murder, Mr. Copeland was amongst the people who fled, the group of alleged YSL members who fled to Miami. That's established already?
No. So that will be established.
Okay.
I did not assert that testimony at trial has revealed this, but I am
Okay.
asserting that it will be established.
Your Honor,
Who all has?
it matters, it was not in the early morning hours. Mr. Copeland's phone records, if you go by phone records, will be several days late.
Okay. Thank you.
Excuse me, Your Honor, I object to the language of it's already been proven in here. I don't mind if she says that there's been evidence that's been submitted, but
Okay.
already been proven, I think is too much.
Noted. Agreed. That's not for us to decide. That's for the jury to decide. So, Ms. Love.
Our position.
That's fine. Our position is fine. But what, so is your evidence going to show that Mr. Copeland went to Miami in the early morning hours after the murder, or is it going to show that several days later?
Not several days later. I believe it was actually, I know that, was it the next day? I think it was the next day that
The murder was,
January 10th.
okay, and he went to Miami.
And then he was in Miami.
Yeah, Love is lying to the court again. She said, she specifically told the judge, this has been proven. It hasn't, because it hasn't even been presented to the jury. And why is that? Because in order for them to get this in, they have to have all the other evidence in before that, including this statement. If they don't get this statement in, they can't go to the Florida trip.
While the state's doing it, if you really care, it's
John, if I
January
may.
6th is the alleged beatdown.
Okay.
Mr. Copeland, it wasn't a week earlier. January 10th, it's going to January 6th. It's at the.
Okay. Thank you.
Crucial. It's a compound.
It was the Sunday before, Your Honor.
Okay.
She doesn't even have the correct facts presented to the judge.
And so the murder is January 10th in the evening. Some YSL members arrived in Miami on the 11th. Mr. Copeland arrived in Miami on the 12th. So the departure from Atlanta by some was hours after
Okay.
the murder. Mr. Copeland gets there on the 12th.
Okay. And do you have evidence that they all congregate together?
Yes.
In Miami? Okay. Okay. And does he go, does your evidence show that he is with anybody else on his trip to Miami? I'm just
Just 1
curious.
second.
Well, at least she is not. But Glanville here would have just sure what the state asserts.
Testified after the recusal motion, that he traveled to Miami with his girlfriend or the mother of his child
Okay.
and his baby.
All right. Thanks.
And also, my understanding, and I believe it was testified to, it may not have been, was just when we're using the word fled, is that Mr. Williams had a show in Miami.
Okay.
Yeah.
So, Your Honor,
He had a show. That's
Mr.
not fleeing. He had an appointment.
Copeland, I believe, has testified already that they were collectively in Miami.
Okay.
Regarding the court-specific question of who he went down there with.
Horrible human being.
We don't
That's
assert
okay.
who he
They were
specifically went down there.
Together once down there. And when did they come back?
They came back at different times. Our phone records, I'd have to look at.
Couple of days later? I mean, just give me a ballpark.
Some, they came back at different times.
Okay.
Different times.
All right. And was there a show for Mr. Williams down there? Some kind of a music show, I assume? You don't
That's
know.
an assertion
Okay.
that we haven't. That's not evidence that we
Okay.
have, or we have put in there. That's not evidence that we
All right.
have.
Well, that might be some.
And there was, so just to also
you
clarify,
lying-
this vehicle.
You lying sack of garbage. You know that all of this is in discovery. You have followed Mr. Williams throughout his career, date by date almost, with not TikToks, but tweets and Instagrams and everything. Miss Love is here lying to the court, claiming they don't know if there was a show there or not. That is a right out lie.
Well, that was rented. It was rented for a certain number of days. It was supposed to be returned, I believe, 3 days after it was returned. So they returned it early. They returned it on the 11th instead of returning it later in the month, as it were. I think, as I said earlier, I believe it was returned about 3 days early. if there was a show, Mr. Williams was aware that he was going to be attending at a particular time on the 11th, the need to keep the car, unless they intended to drive the car to Miami, I would assert should have reflected itself in the way that he secured the rental. If he intended to be at a show,
All right,
then
what date did he rent it?
he rented the Infinity on January 7th, I believe it was. And he returned it on the 11th.
All right.
And the already admitted at trial is the rental agreement that shows that it was due to be returned later after the 11th.
So it was probably a week rental,
Actually, Judge,
maybe? Okay, whatever. You said a few days early, which, okay. All right, so back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence or is it going to be in
that
evidence?
has been already put in evidence
Okay.
and additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth, okay. Between YSL and whatever the gang is
Yes,
that
ma'am.
Mr. Thomas,
Okay,
okay,
yes.
all right.
Specifically, if I may, there were instances that were testified about regarding a particular shooting. So right after the murder of Mr. Thomas, there were a number of shootings that Mr. Copeland was very concerned about and spoke about when he spoke to police in the early morning hours of the 11th, when he himself went down there. He essentially said to them, and I believe that the court has the recording of Mr. Copeland's first interview, they're shooting at me. They think I did it. They being Ifke, they think I did it. And so his girlfriend's father's house was shot up. His brother's house was shot up. Mr. Williams's father or stepfather's house was shot up. There were a number of shootings that have already been testified
All right.
about.
All right.
So just to start with the assertion regarding cohesiveness, that it's not so much a situation where we're asserting that someone is trying to bring Mr. Copeland in to the fold. He's already a part of it. And in alerting him to this happening, this event, he's including Mr. Copeland in on what's going on with the gang. This is our position, so that Mr. Copeland can comport himself appropriately.
All right.
We have noted in our response that when we are talking about a conspiracy, it's not just the conspiracy, it's not regarding the conspiracy of the murder of Donovan Thomas only. The conspiracy is the wider, broader participation in YSL, and the criminal conspiracy is alleged in count 1.
And Ms. Love, is it correct that Mr. Copeland also said to police that after the first revelation that they shot Nutt by Mr. Garlington, that, and that was in the McDonald's parking lot, that either they did or they were then instructed to follow
They did follow them.
the car that had apparently been involved or allegedly been involved, follow that car to
Condo.
another place where they all spent the night,
Hold on just one second.
and that he did so?
This is the judge assuming that the information
We're
from
trying to make certain that the
the club
court
is correct.
is hearing that it's
Not
Mr.
that
Treadwell's vehicle, not the
taking it as
Infiniti,
fact
Okay.
on its
that
face.
they are following to the same place.
Okay, but the vehicle that Garlington's apparently indicates when he says they shot Nutt
Pointed to the white,
means the people in that car.
yeah, the Nitro, yes,
Nitro, okay.
yes, the
sorry.
Dodge Nitro.
Okay. And they then,
Followed the Dodge Nitro.
Mr. Copeland follows the Nitro.
Yes.
And is he directed to, according to him?
I don't know that he says that he's.
Okay, well, anyway, he follows the Nitro and they all spend the night together at an apartment that Mr. Williams has in Midtown.
I don't know that they spend the night. They end up at Mr.
I don't know whether they did either. I'm asking what Mr. Copeland said happened.
That they all go to the
Okay,
home. of
Okay.
Mr. Williams.
okay.
This is so
We ex-
infuriating.
I can
Is it
assert what I
so-
expect other evidence will show that is not yet been shown, but
Other evidence will
other
show.
persons that we expect will testify during the course of this trial will also say that
But that only happens if they get this specific statement in. Then they can move on to the other things. But if that statement in itself, second-hand information told to the police by a person who claims he lies all the time. This is so infuriating.
they met at Defendant Williams' condo. And as reflected in some of the factual acknowledgements of some of the persons who have already entered
The state is saying
negotiated
they will
pleas in
show
this
evidence.
case, they were given
then
money
they
to
have some
lay low.
BS
Members of YSL
testimony
were
from
given
some-
money
yeah.
to lay low following the shooting of Mr. Thomas.
Okay. All right, and so your theory is that,
In alerting
go ahead.
Mr. Copeland to what just took place, it furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly. And they do act accordingly.
Okay.
But that's just a theory.
All right, what about your statement against penal interest argument? I mean, I think that Mr. Sharp raises kind of a good point that how can it be against Mr. Garlington's penal interest to say somebody else did the shooting?
It wasn't just the shooting. He also, Mr. Copeland, that he has also talked about Mr. Garlington's words to him regarding his presence and his knowledge of who it was that participated in the Little Wayne bus shooting as well.
Okay,
And
so this is an entirely different shooting.
there were two, yes. two
Right,
different.
so let's focus right now on what he said, the hearsay about the Thomas shooting.
Okay.
How is that against Mr. Garlington's penal interest?
It's Mr. Garlington, as we said, is providing information about we argue, a gang-motivated crime committed by members of the same gang that he
This is just word salad.
a member of. So in saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He's a member of the same criminal conspiracy as those that
This is just
he's
the same
called
argument again.
murderers
Address
and
what
shooters
we asked
in
you
the
to.
Little Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder or the shooting.
But
He would
Copeland
not
has.
be privy to the information that they just killed Nutt had he not been a part of that same gang that these persons that he alleged have just killed Nutt are also parts of.
All right, so is your theory then that when he says this, it reveals that he's a part of this same gang and therefore he can be charged under a gang count?
No, he has he's, because of his involvement. So it's not just that, it's not so much that he can be charged under
Well,
a
a
gang
statement
count.
against penal interest would require that what you say could get you arrested and convicted of a crime, right?
Correct.
So how is what he said going to do that?
It is evidence of his membership in a criminal conspiracy that is YSL. The act that they have committed is evidence that this enterprise commits criminal acts. It subjects him to punishment under count 1 in our indictment.
So as a RICO charge, not even a gang charge, a
Well,
RICO charge.
A RICO charge and a gang charge, to be clear, because in our case, the RICO charge is
involving the criminal enterprise that is YSL, the criminal street gang. Mr. Garlington is a member of YSL, the criminal street gang. Part of what is necessary to prove a criminal street gang even exists is the fact that members commit crimes to further the interests of the gang. He is acknowledging that a group that he is a member
Love
of
of all is holy, please, Judge,
commits these type of crimes that he is talking about. That acknowledgement can subject him to punishment for acts that he commits as part of or in furtherance of the
Yes,
criminal
for acts
street
that
gang.
he commits. He hasn't, by this particular statement, admitted to committing any acts, right? He's saying somebody else did. All right.
As it relates to the shooting, he didn't do that.
Okay. All right. Okay, anything else on this issue?
Just 1 second, Your Honor.
Mahida de Jesus, Ms. Love sounds like a person unqualified during an interview for work. Yeah, I wouldn't hire her to clean toilets. Hi, Lexi. Oh.
And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas before the murder.
Okay.
But Mr.
Also
Garlington haven't
reflects
said
his
any of this.
involvement
This is
in
Copeland's
the gang
statement.
itself.
Okay. All right. Sure.
And Judge, if I
Hang
may,
on,
before
she might not
Mr.
be done. Go ahead.
Apologize.
That's okay.
I would cite the court to United States versus Padilla, P-A-D.
Is this a new case that's not in your response?
It's
Okay.
not.
Okay, all right.
And here they go again. While
Yes,
she,
Padilla.
Yes.
What's the site?
and this happened all the time with Judge Glanville. Ms. Love is on the pulpit buying time because she already knows she has rubbish case law, and then they pull something out of a hat that they haven't presented to the defense, but now argues towards the judge.
It is 2000 US APP Lexus 1843 at
This is all just theory. They want this RICO charge to be, it will allow every piece of garbage in. And sadly, the Georgia RICO Act does that to a certain extent, to the judge's discretion, to allow any piece of garbage in, any piece of bingo lady gossip as evidence under a theory of a conspiracy.
At
5, page 5.
Okay. All right, 2000 US APP Lexus 1843 at 5.
Yes.
Okay. All right.
Wherein the court says that we reject the arguments of Padilla and Rodriguez that the district court erred in admitting plea allocutions of 5 co-defendants. The district court found that all of the co-defendant statements being admitted into evidence were self-inculpatory
involving inter alia admission
Listen carefully here. I know exactly where she's going. I don't know this specific case, but I know exactly where she's going with this.
of membership in the named RICO conspiracy, and the court declined to reverse the district court's finding as an abuse of discretion. So in his statements, we would argue inculpate him.
But it's not his statements. It's reference by another person that claims he said it. There is no recording, no transcript, no anything where Mr. I forget his name actually said it. And just a blanket, all statements are allowed in. It's impossible.
In the RICO conspiracy that we have alleged in this case.
Okay. Thank you. Mr. Sharp.
So, John, I think it's clear that this is not a statement against penal interest. It's what a reasonable person would believe. And to come up with these theories about RICO conspiracies when you haven't done anything wrong, I just don't see that as falling under that exception to the hearsay rule. Regarding the statements, whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements about the alleged murder. Apparently he said, can you come pick me up? Sure. He went down there. A statement, we say it was never made. Mr. Copeland now says it was never made, but regardless, the statement, if it was made, it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows. Okay. The state is arguing that narrative events given so someone can comport themselves appropriately makes a statement in furtherance of conspiracy. And if we just logically think about that, that would mean that any time there's a declarant and someone else and a witness who are allegedly involved in the same conspiracy or in the same gang or anything else, anytime a statement of narrative events is made from declarant to witness and they're linked together in any sort of alleged gang or conspiracy, by definition, it would fall under this exception. And that's just not the case. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory. And it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything. And, if we were to just allow those spilling the beans statements in under that just imagined alleged basis, then the rule really doesn't even need to exist and the exception would swallow the rule. So it doesn't fall under either of the exceptions asserted by the state.
All right, thank you.
Your Honor, may I add one thing briefly?
Yes.
I just point out that the cases that were cited by defense in support for their position, those were not gang cases. Ours specifically, the cases that we cite are gang cases. We cite a plethora of gang cases. And in doing so, we express how here there is a distinction between the case that we have and the cases that they are citing, and that we are specifically talking about the criminal conspiracy of the YSL street gang. The argument that any statement made for a narrative purpose
would be admissible is inapplicable here, where the statement that was made was not just any statement for a narrative purpose. It was a statement about a criminal act committed by a co-gang member, a co-YSL member or members of the enterprise that this young man, Damikion Garlington, is alleged by.
This is not adding anything. You're just rehashing what you already said.
The state, and we believe can be proven to also be a member of. Additionally, we will be at trial later on, presenting evidence from other sources of what took place at that condo, which further show what we are arguing here.
All right. Let's break for lunch. We're probably a little bit on the late side for breaking for lunch, but it is 12:35. Let's come back at 1:45.
I'm so infuriated.
Mr. Steele, I'm going to give you your copy of that transcript back. Thank you for loaning it to me.
I do have one thing, because I need to finish this. This is the third attempt of doing this, but sorry if you haven't watched it. What I will do is, after I go take down the stream, I will cut out these portions so at least it looks like coherent, because a bunch of my viewers have not seen Mr. Harvey's reply or reply to the state's response. He says, neither does the state explain how the court will make other necessary decisions without being present or familiar with the record. One of the most consequential powers of the trial judge is the authority to act as the 13th juror. Now, sadly, Judge Whitaker rewarded, well, she hasn't made it public yet, let's just say that. But it seems like she's rewarding the horse crap that the state presented as response to this. As the Georgia Supreme Court held in Wilkerson v. State, even when the evidence in legal is sufficient to sustain a conviction, a trial judge may grant a new trial if the verdict of the jury is, quote, contrary to the principles of justice and equity, or if the verdict is, quote, decidedly and strongly against the weight of the evidence. When properly raised in a timely motion, these grounds for a new trial, commonly known as the general grounds, require the trial judge to exercise broad discretion to sit as a 13th juror. In exercising that discretion, the trial judge must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflict in the evidence, the credibility of witnesses, and the weight of the evidence. Here I agree with completely. I agree with Mr. Harvey. Because even if she goes and looks at the YouTube, some of these witnesses has not been shown. So how can she assess that? She can't. Let's continue. Let's go through this. As J. Bethel further explains in his concurrence, collectively, are commonly called the general grounds and have been referred to as the 13th juror, ruled by the bench and a bar of this state. These rules create a weighty and long-standing power designed to provide the trial court with an opportunity to avoid an injustice. As this court has noted, the general grounds ask whether the trial judge is personally satisfied with the jury's verdict. Trial judge retain the strongest of discretions when reviewing motions based on the general grounds. This authority is vested in the trial court and necessarily involves questions of fact and the independent weighing of the evidence. Therefore, we must decline to substitute our judgment for the judgment of the trial court. Now, Judge Whitaker's explanation was that there has been judges who has reviewed this without seeing it before, and it will happen again. I'm not sure which judges she meant, if she meant a review from the superior court or review from appeals court. In this case, the mid-trial substituted judge did not attend over half a year of testimony. Trial thus far has not been just fact-laden testimony of custodians of records. Rather, this trial has included crucial testimony which must be personally observed and experienced by jurors, including the 13th juror. Take, for example, the testimony of the witness whose antics on the stand led to his jailing for contempt. The testimony of a witness who accused another state witness of having engaged in abuse of authority, attempts to influence witnesses, and improper sexual advances. The testimony of a purported witness to an alleged crime who testified that no such crime was in fact witnessed. The testimony of a witness who directly contradicted previous sworn statements and now testifies that those previous statements were fabricated. This trial may very well hinge on conflicts of the evidence and the credibility of witnesses, as contemplated by the Georgia Supreme Court in Wilkerson. Accordingly, in this case, it is simply not possible for a judge without personal observation of the witnesses and the testimony to be our 13th juror. Further, Nichols notes that the original 19-month trial judge made numerous contingent decisions addressing admissibility of evidence, the need for curative instructions, the need for severance as the case progressed, etc. The state did not dispute these facts and offered no argument specifying how the mid-trial substituted judge could make these rulings without familiarity with the entire record and the testimony of witnesses. Yeah, I mean, the gang expert, Detective Belknap, whatever his name is. I do believe that the Atlanta Police Department's gang unit is where the absolute most incompetent cops sooner or later end up in. Just see with Officer Godier, or Gaither, or whatever her name is pronounced. I have never, in my 30 plus years in law, seen a more incompetent cop than her in my entire career. And then let's continue. Unfamiliarity with the record. The state appears to concede that most jurisdictions have adopted rules of procedure requiring a substituted judge to certify on the record their familiarity with the previous trial proceedings. In Georgia, this is inferred from the U.S. Constitution, including the 5th, 6th, and 14th Amendments, as well as the Georgia Constitution, and its requirements for due process and a fair trial. The court's familiarity with the record is needed to make every decision, including, but not limited to, litigation decisions, admissibility decisions, credibility decisions, directed verdict, acting as 13th jury instructions, severance, mistrials, and more. Furthermore, logic, fundamental equity, and society's interest all support the proposition that, particularly when the defendant's liberty is at stake, the court must know what has occurred during the trial to ensure fairness and to make informed legal rulings. Anything less does not conform with the concept of a fair trial. Lacking any cogent rationale, the state resorts to its usual slippery slope scare tactic, disingenuously claiming that accepting Mr. Nichols' arguments risks setting a precedent that would preclude mid-trial substitution of any judge in any case. Comparing the length and issues which have occurred during this trial and a normal trial is like comparing a minnow to a whale. Here, Mr. Nichols merely contends that in this case, given the unprecedented length of the trial, the amount of testimony which has already occurred, the need for personal observation, the vast number of deferred rulings in various states of limbo, the witnesses which were excluded from video recordings, and the portions of the trial which were not recorded at all. This court cannot timely and adequately familiarize itself with this trial record and cannot suitably proceed without such familiarization. Roy Lonsinger said, so when my 4 children, their spouses, grandchildren, and my wife and I go to an event wearing the same colors, we must be a gang. Yeah, that's the state's case. Recess of trial. The state concedes that mid-trial recess is unusual, but misses the point. Recess is a basis for a mistrial when it results in an unfair trial. The jurors has been sworn in for 9 months. The trial has been actively suspended for over a month and counting. The jury continued to hear witness testimony after the defendants moved for the trial judge's recusal. The jury cannot erase that portion of the trial. Sadly, it seems like Ms. Whitaker says they can, with a simple instruction. You have to ignore that, which is moronic. The jurors are expected to resume trial under the auspices of a new judge, and if that won't have its own implications in their minds, the jurors are expected to remember what they heard and observed months ago. The state has offered to help familiarize this court with the previous proceedings. Even if that was possible, how long will that take while the jury remains held in abeyance? Not to mention, the state has over 100 witnesses remaining. Unfortunately, this trial is irretrievably broken, and the jury can reasonably be expected to resume its role unaffected. In arguing that the recess is not disruptive, the state relies on non-presidential cases where a recess occurred during jury deliberation when the jury was in a car accident. Defense counsel's illness prompted a recess. A recess based on defendant's hospitalization lasted more than 1 month. From these non-binding off-topic anecdotes, the state somehow concludes that the recess in the instant case is not a basis for mistrial. There is nothing more than the state's desperate attempt at misdirection. The facts in this case are entirely different from those cited by the state. In this case, the recess is a further disruption to the jury necessitated by the recusal of the trial judge, not an accommodation to illness or injury. Number 6, severance. Once again, the state misses the point. Nichols' argument in his motion and objection was that the previous judge has repeatedly stated that Mr. Nichols' request for severance was under advisement and could become necessary at some point. This court was not present as the case has evolved and will therefore be unable to make an informed decision based on a record with which this court is unfamiliar. Here, Judge Whitaker said, well, you have to tell me. She said that to Mr. Harvey. So she put that on Mr. Harvey to make her informed. Wherefore, the defendant moves this court for a hearing on this motion for mistrial and objection to the mid-trial substitution of the trial judge. Submitted by Bruce Harvey. And certificate of service. All right, we finally got through that. And yeah, we are a good number of before this court returns from lunch. I'm going to do it like this. I'm going to send you over to Kat, not Williams, because I don't have content for you for the rest of this lunch. So I will continue tomorrow morning with the afternoon part of this hearing. I will continue as soon as I get home from work. We're going to play it in 1.25 or 1.5. We can skip over all the parts where everybody is silent or shuffling papers or stuff like that. And this is a good argument here. Preacherman 101. What lawyer Love and Hilton do not realize is they're on trial as well in the court of public opinion, and right now they are looking guilty. I completely agree. So now it's also up to you guys. I mean, we have all the lawyers and all the laymen who do the trial coverage of this trial. Your part of this is giving all the thumbs up, all the subscription to the people who cover this, and share on your social media and be vocal on social media. Because sooner or later, especially if this goes up, if this goes on, and this judge starts making absolutely horrific rulings, the court of public opinion, you are the 13th juror in this case. You are. You have more information that the jurors in this case have. So be vocal. Show the world that you care about due process, folks. That you care about fair trials, the Constitution and the Bill of Rights. Be vocal. All right, rant over. Okay, folks. I will see you back here tomorrow. I will go live as soon as I can. Everybody say hi to Catnot Williams for me. And thank you for being here. Thank you for allowing me to do this, to try to transcribe this fustercluck of a trial for you. Until we see each other again, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.